University has joined, sir.
Okay, namaskara sir.
ನಮಸ್ಕಾರ ಸರ್. ನಮಸ್ಕಾರ
ನಮಸ್ಕಾರ
ನಮಸ್ಕಾರ ಸರ್. ಪ್ರೊಫೆಸರ್ ದಶರಥ್ ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ.
ನಮಸ್ಕಾರ ಸರ್. ನಮಸ್ಕಾರ ನಮಸ್ಕಾರ.
Dashrath sir.
Oh, Dashrath sir.
ನಮಸ್ತೆ ನಮಸ್ತೆ.
ನಮಸ್ಕಾರ ನಮಸ್ಕಾರ. Can you hear me?
Yes sir, yes sir, sure sir.
Thank you.
ಸರ್ ಒಂದೆರಡು ನಿಮಿಷ ಜಾಯ್ನ್ ಆಗ್ತಾರ? ನಾಡಗೌಡ್ ಸರ್
ಆಗ್ಲಿ ಆಗ್ಲಿ. ಎಷ್ಟು 6:10 ಇದ್ದಿದ್ದು?
ಹೌದು ಸರ್, 6:10.
ಓಕೆ.
ಅಂದ್ರೆ 6 ಗಂಟೆ ಅಂತ ಹೇಳಿದ್ರೆ ಜನಗಳಿಗೆ 10 ನಿಮಿಷ ಮಾರ್ಜಿನ್ ಸಿಗುತ್ತೆ ಸರ್. 6 ಅಂತ ಹೇಳಿರ್ತೀವಿ, 6:10 ಜಾಯ್ನ್ ಆಗ್ತಾರೆ ಸರ್. ಅದೊಂದು ಟೆಕ್ನಿಕಲ್ ಅಷ್ಟೇ ಸರ್. Miss sir, Professor Dashrath sir ಅವರು senior professor from Bangalore University Law College sir.
Sir, welcome sir. Welcome Professor Dashrath ಅವರೇ. ನಮಸ್ಕಾರ.
Thank you so much sir. Thank you for your kind words. Thank you sir.
Sir, convener is senior advocate Sri Amit Kumar Deshpande sir. ಶುರು ಮಾಡ್ಬೋದು ಸರ್. ಸರ್ ಜಾಯ್ನ್ ಆಗ್ತಾರಲ್ತಾನ. ಅಮಿತ್ ಸರ್. ಅಮಿತ್ ಸರ್.
ವಿಜ್ಞಾನೇಶ್ವರ ಪ್ರತಿಷ್ಠಾನ ಮರ್ತೂರ್ ಸಹಯೋಗ ಕರ್ನಾಟಕ ಕೇಂದ್ರೀಯ ವಿಶ್ವವಿದ್ಯಾಲಯ ಕಡಗಂಚಿ ಕಲಬುರಗಿ ಮತ್ತು ಕರ್ನಾಟಕ ಕಾನೂನು ವಿಶ್ವವಿದ್ಯಾಲಯ ಹುಬ್ಬಳ್ಳಿ ಗೌರವಾನ್ವಿತ ನ್ಯಾಯಮೂರ್ತಿ ಡಾಕ್ಟರ್ ಮ ರಾಮ ಜೋಯಿಸ್ರ 94ನೇ ಹುಟ್ಟುಹಬ್ಬದ ಆಚರಣೆಗಾಗಿ ಸರಣಿ ಉಪನ್ಯಾಸ ಕಾರ್ಯಕ್ರಮಗಳು. ನಾನು ಅಮಿತ್ ಕುಮಾರ್ ದೇಶಪಾಂಡೆ, ಕಾರ್ಯಕ್ರಮದ ಸಂಯೋಜಕರು. ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. ಅಧ್ಯಕ್ಷರಾದ ಶ್ರೀ ಬಸವರಾಜ್ ಪಾಟೀಲ್ ಸೇಡಂ, ವಿಶ್ವಸ್ತರಾದ ಶ್ರೀ ಮಹಾದೇವಯ್ಯ ಕರ್ದಳ್ಳಿ ಅವರ ಮಾರ್ಗದರ್ಶನದಲ್ಲಿ ವಿಜ್ಞಾನೇಶ್ವರ ಪ್ರತಿಷ್ಠಾನ ಮರ್ತೂರ್, ಕರ್ನಾಟಕ ಕೇಂದ್ರೀಯ ವಿಶ್ವವಿದ್ಯಾಲಯ ಕಡಗಂಚಿ, ಕಲಬುರಗಿ ಮತ್ತು ಕರ್ನಾಟಕ ಕಾನೂನು ವಿಶ್ವವಿದ್ಯಾಲಯ ಹುಬ್ಬಳ್ಳಿ ವತಿಯಿಂದ ಉಪನ್ಯಾಸ, ವಿಚಾರ ಸಂಕಿರಣ, ಸಮ್ಮೇಳನ ಮುಂತಾದ ಕಾರ್ಯಕ್ರಮಗಳನ್ನು ಆಯೋಜಿಸುತ್ತಿರುವುದು ತಮಗೆ ತಿಳಿದಿರುವ ವಿಷಯವಾಗಿದೆ. ಪ್ರತಿ ವರ್ಷದಂತೆ ಈ ವರ್ಷವೂ ಗೌರವಾನ್ವಿತ ನ್ಯಾಯಮೂರ್ತಿ ಡಾಕ್ಟರ್ ಮ ರಾಮ ಜೋಯಿಸ್ ರವರ 94ನೇ ಹುಟ್ಟುಹಬ್ಬವನ್ನು ಆನ್ಲೈನ್ ನಲ್ಲಿ ಆಚರಿಸುತ್ತಿದ್ದೇವೆ. ಸರಣಿ ಉಪನ್ಯಾಸಗಳ ಮಾಲಿಕೆಯಲ್ಲಿ ಮೊದಲ ಉಪನ್ಯಾಸವನ್ನು ಜುಲೈ 22ರಂದು ಆಚರಿಸಲಾಗಿದೆ. ಇವತ್ತು 4ನೇ ಉಪನ್ಯಾಸ ಡಾಕ್ಟರ್ ಮ ರಾಮ ಜೋಯಿಸ್ ರವರು ಸರಳ ಸಜ್ಜನಿಕೆಯ ಸಾಕಾರ ಮೂರ್ತಿ, ಸಮಾಜದಲ್ಲಿನ ಬಡವರ ಬಗ್ಗೆ ಮತ್ತು ಪರಿಶಿಷ್ಟ ಜಾತಿ ಪಂಗಡಗಳ ಬಗ್ಗೆ ಅಪಾರ ಕಾಳಜಿಯುಳ್ಳವರು, ಭಾರತೀಯ ನ್ಯಾಯಶಾಸ್ತ್ರ ಕುರಿತು ಆಳವಾದ ಅಧ್ಯಯನ ಮಾಡಿದವರು, ರಿಲಿಜನ್ ಮತ್ತು ಧರ್ಮದಲ್ಲಿನ ವ್ಯತ್ಯಾಸ ಭಾರತೀಯರಿಗೆ ಮನಗಾಣಿಸಿದರು, ಮೇರು ವ್ಯಕ್ತಿತ್ವದ ನ್ಯಾಯಮೂರ್ತಿಗಳ ವಿಚಾರಗಳನ್ನು ಸಮಾಜದ ಕಟ್ಟಕಡೆಯ ವ್ಯಕ್ತಿಗೆ ಮತ್ತು ಯುವ ಪೀಳಿಗೆಗೆ ತಲುಪಿಸುವ ಸಾಧನವನ್ನಾಗಿ ಅವರ ಜನ್ಮದಿನದ ಅರ್ಥಪೂರ್ಣ ಆಚರಣೆ ಆಯೋಜಿಸಲಾಗಿದೆ. ಸಂತೃಪ್ತ ಮತ್ತು ಸಮೃದ್ಧ ಪಾರಿವಾರಿಕ ಜೀವನ ನಡೆಸಿದವರು. ಅವರ ಜನ್ಮದಿನದ ಸಂದರ್ಭದಲ್ಲಿ ಅವರಿಗೆ ಪ್ರಿಯವಾದ ಭಾರತೀಯ ಕಾನೂನು ಶಾಸ್ತ್ರ ಜೊತೆಗೆ ಪ್ರಸ್ತುತ ಕಾನೂನು ಅಧ್ಯಯನ ಕುರಿತಂತೆ ತಜ್ಞರಿಂದ ಉಪನ್ಯಾಸಗಳನ್ನು ಏರ್ಪಡಿಸಲಾಗಿದೆ. ಇಂದಿನ ಕಾರ್ಯಕ್ರಮದ ಅತಿಥಿ ಉಪನ್ಯಾಸಕರನ್ನು ಅಧ್ಯಕ್ಷರನ್ನು ಪರಿಚಯ ಮಾಡಿಸಿ ಸ್ವಾಗತಿಸಲು ಶ್ರೀ ಮಹಾದೇವಯ್ಯ ಕರದಳ್ಳಿಯವರನ್ನು ನಾನು ವಿನಂತಿಸುತ್ತೇನೆ. ಮಹಾದೇವಯ್ಯ ಅವರು.
ನಮಸ್ಕಾರ ಸರ್. ಸುರೇಶ್ ಸರ್ ಅವರಿಗೆ, ಪ್ರೊಫೆಸರ್ ಸುರೇಶ್ ಸರ್ ಅವರಿಗೆ ಸ್ವಾಗತ ಸರ್.
ನಮಸ್ಕಾರ ಸರ್. ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ವೆಲ್ಕಮ್ ಸರ್, ವೆಲ್ಕಮ್. ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಇಂದು ಉಪನ್ಯಾಸ ನೀಡಲು ಆಗಮಿಸಿದ ನಮ್ಮೆಲ್ಲರ ಆತ್ಮೀಯರು, ಹಿರಿಯರಾದಂತಹ ವಿಶ್ರಾಂತ ಪ್ರಿನ್ಸಿಪಲ್ ಜಿಲ್ಲಾ ಮತ್ತು ಸತ್ರ ನ್ಯಾಯಾಧೀಶರಾಗಿದ್ದ ಶ್ರೀ ಡಿ.ಆರ್. ವೆಂಕಟ ಸುದರ್ಶನ್ ಅವರನ್ನು, ಅಧ್ಯಕ್ಷತೆಯನ್ನು ವಹಿಸಲಿರುವ ಕರ್ನಾಟಕ ರಾಜ್ಯ ಗ್ರಾಮೀಣ ಮತ್ತು ಪಂಚಾಯತ್ ರಾಜ್ ವಿಶ್ವವಿದ್ಯಾಲಯ ಗದಗದ ಪ್ರಭಾರಿ ಕುಲಪತಿಗಳು, ಕುಲಸಚಿವರಾದ ಪ್ರೊಫೆಸರ್ ಡಾಕ್ಟರ್ ಸುರೇಶ್ ವಿ ನಾಡಗೌಡರನ್ನು, ಕರ್ನಾಟಕ ಕಾನೂನು ವಿಶ್ವವಿದ್ಯಾಲಯದ ಮಾನ್ಯ ಕುಲಪತಿಗಳಾದ ಪ್ರೊಫೆಸರ್ ಡಾಕ್ಟರ್ ಸಿ ಬಸವರಾಜ್ ಅವರನ್ನು, ಕರ್ನಾಟಕ ಕೇಂದ್ರೀಯ ವಿಶ್ವವಿದ್ಯಾಲಯದ ಕುಲಪತಿಗಳಾದಂತ ಮಾನ್ಯ ಶ್ರೀ ಭಟ್ಟು ಸತ್ಯನಾರಾಯಣ ಅವರನ್ನು, ಹಾಗೂ ಕರ್ನಾಟಕ ವಿಶ್ವವಿದ್ಯಾಲಯ ಕಡಗಂಚಿ ಕಲಬುರಗಿ ಡೀನ್ ಮತ್ತು
ಅಲ್ಲಿ ಕೊಡ್ರಿ ಅವ್ರಿಗೆ. ನಿಮ್ದು ಆಯ್ತಲ್ಲ, ಹೋಗ್ರಿ ನೀವು ಹೋಗಿ.
ಸರ್ ಬಸವರಾಜ್ ಅವರನ್ನು, ಆನಂತರ ಕಲ್ಯಾಣ ಕರ್ನಾಟಕದ ಎಲ್ಲ ಪ್ರಾಚಾರ್ಯರು, ಉಪನ್ಯಾಸಕರು, ನ್ಯಾಯಮೂರ್ತಿ ರಾಮಜೋಯಿಸ್ ಅವರ ಪರಿವಾರ ಸದಸ್ಯರು, ವಿಶ್ರಾಂತ ರಾಜ್ಯಸಭಾ ಸದಸ್ಯರು, ನಮ್ಮ ಪ್ರತಿಷ್ಠಾನದ ಮಾನ್ಯ ಅಧ್ಯಕ್ಷರಾದಂತಹ ಬಸವರಾಜ್ ಪಾಟೀಲ್ ಸೇಡಂ ಅವರು, ಸರ್ ವಿಶ್ವಸ್ತರಾದಂತಹ ಸುರೇಶ್ ಬುಲ್ಬುಲಿ ಅವರು, IAS ಅಧಿಕಾರಿಗಳಾದಂತಹ ಶ್ರೀ ಲಕ್ಷ್ಮೀನಾರಾಯಣ ಅವರು, ಗುಂಡಪ್ಪ ಕಂಬಾರ್, ಡಾಕ್ಟರ್ ವಾಸುದೇವ್ ಸೇಡಂ, ವಿಕ್ರಮ್ ಪಡ್ಕೆ ಅವರು, ಪ್ರೊಫೆಸರ್ ಎಂ ಕೊಟ್ರೇಶ್ ಅವರು, ಮರ್ತೂರಿನ ಡಾಕ್ಟರ್ ಬಸವರಾಜ್ ಪಾಟೀಲ್, ಯೋಗೇಶ್ವರಿ ಅಗ್ನಿ ಸಮಿತಿ ಅಧ್ಯಕ್ಷರು, ಅಮಿತ್ ದೇಶಪಾಂಡೆ ಅವರು ಮತ್ತು SP ಪಾಟೀಲ್, ಎಲ್ಲ ವಿಶ್ವಸ್ತರನ್ನ, ವಿಶ್ವವಿದ್ಯಾಲಯದ ಅನ್ಯಾನ್ಯ ವಿಶ್ವವಿದ್ಯಾಲಯಗಳ ಮಾನ್ಯ ಉಪಕುಲಪತಿಗಳು, ಮಾನ್ಯ ನ್ಯಾಯಾಧೀಶರು, ಅನ್ಯಾನ್ಯ ಕಾನೂನು ಮಹಾವಿದ್ಯಾಲಯಗಳ ಪ್ರಾಚಾರ್ಯರು, ಕಲ್ಯಾಣ ಕರ್ನಾಟಕದ ಕಾಲೇಜುಗಳ ಉಪನ್ಯಾಸಕರು ಮತ್ತು ಪ್ರಾಚಾರ್ಯರು, ವಿದ್ಯಾರ್ಥಿಗಳು, ನ್ಯಾಯವಾದಿಗಳು ಎಲ್ಲರನ್ನೂ ಸುಸ್ವಾಗತವಾಗಿ ಕೋರುತ್ತೇನೆ ಮತ್ತು ಮಾನ್ಯ ಅತಿಥಿಗಳ ಸಂಕ್ಷಿಪ್ತ ಪರಿಚಯವನ್ನು ಮಾಡಿಕೊಡುತ್ತೇನೆ. ಇಂದು ಉಪನ್ಯಾಸ ನೀಡಲಿರುವ ವಿಜ್ಞಾನೇಶ್ವರ ಪ್ರತಿಷ್ಠಾನದಿಂದ ಸುಮಾರು 1.5-2 ದಶಕಗಳಿಂದ ಜೊತೆಗೂಡಿರ್ತಕ್ಕಂಥ ಆದರಣೀಯ ಶ್ರೀ ಡಿ.ಆರ್. ವೆಂಕಟ ಸುದರ್ಶನ್ ರವರು ನಮಗೆಲ್ಲ ಚಿರಪರಿಚಿತರು. ಈಗಾಗಲೇ ನಮ್ಮ ಅನೇಕ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಭಾಗವಹಿಸಿದ್ದಾರೆ, ಸಂಪನ್ಮೂಲ ವ್ಯಕ್ತಿಗಳಾಗಿ ಬಂದು ಉಪನ್ಯಾಸ ನೀಡಿದ್ದಾರೆ. ಸಂಕ್ಷಿಪ್ತದಲ್ಲಿ ಪರಿಚಯ ಹೇಳೋದಾದ್ರೆ, ಶ್ರೀಯುತರು ವಿಶ್ರಾಂತ ಪ್ರಿನ್ಸಿಪಲ್ ಜಿಲ್ಲಾ ಮತ್ತು ಸತ್ರ ನ್ಯಾಯಾಧೀಶರಾಗಿದ್ದರು ಮತ್ತು ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಕನ್ಸ್ಯೂಮರ್ ಕೋರ್ಟ್ ಜ್ಯುಡಿಷಿಯಲ್ ಕಮಿಷನ್ ಅಧ್ಯಕ್ಷರಾಗಿ ಸೇವೆ ಸಲ್ಲಿಸಿದ್ದಾರೆ. ನೂತನವಾಗಿ ಆಯ್ಕೆಯಾಗಿರ್ತಕ್ಕಂಥ ನ್ಯಾಯಾಂಗ ಇಲಾಖೆ ಅಧಿಕಾರಿಗಳಿಗೆ ತರಬೇತಿ ನೀಡತಕ್ಕಂಥ ಕರ್ನಾಟಕ ಜುಡಿಷಿಯಲ್ ಅಕಾಡೆಮಿಯ ಸಂಪನ್ಮೂಲ ವ್ಯಕ್ತಿಗಳಾಗಿ ಸೇವೆ ಸಲ್ಲಿಸಿದ್ದಾರೆ. ಸಹೃದಯರು, ಸದಾ ಕ್ರಿಯಾಶೀಲ ವ್ಯಕ್ತಿತ್ವದವರು, ವಿಶ್ರಾಂತ ಜೀವನದಲ್ಲಿದ್ದರೂ ಅವಿಶ್ರಾಂತವಾಗಿ ತಮ್ಮ ಜ್ಞಾನದಾಸೋಹ ಸೇವೆಯನ್ನು ಮುಂದುವರಿಸಿದ್ದಾರೆ. ಪ್ರತಿಷ್ಠಾನದ 10 ಚಟುವಟಿಕೆಗಳಿಗೆ ಬೆಂಗಾಲಾಗಿ ನಿಂತು ಮಾರ್ಗದರ್ಶನ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಅವರಿಗೆ ಸುಸ್ವಾಗತ ಸರ್. ಸ್ವಾಗತ ಸರ್, ಸ್ವಾಗತ.
ನಮಸ್ಕಾರ ಸರ್.
ಇವತ್ತಿನ ಕಾರ್ಯಕ್ರಮದ ಅಧ್ಯಕ್ಷತೆಯನ್ನು ವಹಿಸಿದಂತ ಕರ್ನಾಟಕ ರಾಜ್ಯ ಗ್ರಾಮೀಣಾಭಿವೃದ್ಧಿ ಮತ್ತು ಪಂಚಾಯತ್ ರಾಜ್ ವಿಶ್ವವಿದ್ಯಾಲಯದ ಗದಗದ ಪ್ರಭಾರಿ ಕುಲಪತಿಗಳು, ಕುಲಸಚಿವರಾದಂತಹ ಪ್ರೊಫೆಸರ್ ಡಾಕ್ಟರ್ ಸುರೇಶ್ ವಿ ನಾಡಗರ್ ಅವರು, ಬೆಂಗಳೂರು, ನಮಗೆ ಚಿರಪರಿಚಿತರು. ಈ ಹಿಂದಿನ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಅವರು ಭಾಗವಹಿಸಿದ್ದಾರೆ. ಅವರ ಪರಿಚಯ ಸಂಕ್ಷಿಪ್ತದಲ್ಲಿ ಮಾಡಿಕೊಡುತ್ತೇನೆ. ವಿಶ್ವವಿದ್ಯಾಲಯದಲ್ಲಿ ಹಲವು ದಶಕಗಳ ಕಾಲ ಪ್ರೊಫೆಸರ್ ಆಗಿ ಅಧ್ಯಾಪನದಲ್ಲಿ ಅನುಭವವನ್ನು ಹೊಂದಿದ್ದಾರೆ. ಅನೇಕ ಸಂಶೋಧನಾ ವಿದ್ಯಾರ್ಥಿಗಳಿಗೆ ಮಾರ್ಗದರ್ಶನ ಮಾಡಿದ್ದಾರೆ. ಡೀನ್ ಆಗಿ, ಕುಲಸಚಿವರಾಗಿ ಬೆಂಗಳೂರು ವಿಶ್ವವಿದ್ಯಾಲಯದಲ್ಲಿ, ಕರ್ನಾಟಕ ಕಾನೂನು ವಿಶ್ವವಿದ್ಯಾಲಯ ಹುಬ್ಬಳ್ಳಿಯಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸಿ ಆಡಳಿತಾತ್ಮಕವಾಗಿ ಅಪಾರ ಅನುಭವ ಹೊಂದಿದ್ದಾರೆ. ಕರ್ನಾಟಕ ಸರ್ಕಾರದ ಹಲವು ಹುದ್ದೆಗಳಲ್ಲಿ ಜವಾಬ್ದಾರಿ ನಡೆಸಿದ್ದಾರೆ. 2004-5ರಲ್ಲಿ ಪಾಲಿಸಿ ಅಂಡ್ ಆಕ್ಷನ್ ಪ್ಲಾನ್ ತಯಾರು ಮಾಡಿಸಿದ್ದಾರೆ. 2014-15ರಲ್ಲಿ ಕರ್ನಾಟಕ ಕಾನೂನು ಆಯೋಗ ಸದಸ್ಯರಾಗಿ ಮತ್ತು RDPR ಯೂನಿವರ್ಸಿಟಿ ಬಿಲ್ ಅನ್ನು 2016 ರೂಪಿಸುವಲ್ಲಿ ಸೇವೆ ಸಲ್ಲಿಸಿದ್ದಾರೆ. ಅವ್ರನ್ನ ಹುಡುಕಿಕೊಂಡು ಹಲವು ಪ್ರಶಸ್ತಿಗಳು ಬಂದಿವೆ. ಅನೇಕ ಗ್ರಂಥಗಳನ್ನು ಪ್ರಕಟಿಸಿದ್ದಾರೆ. 16 ಪ್ರಮುಖ ಸಂಸ್ಥೆಗಳ ಸದಸ್ಯರಾಗಿ ಸೇವೆ ಸಲ್ಲಿಸಿದ್ದಾರೆ. ಸದಾ ಕ್ರಿಯಾಶೀಲ ವ್ಯಕ್ತಿತ್ವದ ಸಹೃದಯರಾದ ಪ್ರೊಫೆಸರ್ ನಾಡಗೌಡರಿಗೆ ಪ್ರತಿಷ್ಠಾನದ ಕಾರ್ಯಕ್ರಮಗಳಲ್ಲಿ ಬಿಡುವು ಮಾಡಿಕೊಂಡು ಬೆಂಬಲಿಸಿ ಭಾಗವಹಿಸಿ ಸಹಕರಿಸಿದ್ದಾರೆ. ಅವರ ಮಾರ್ಗದರ್ಶನಕ್ಕಾಗಿ ಅತ್ಯಂತ ವಿದ್ವತ್ ಪರಿಪೂರ್ಣ ಇರ್ತಕ್ಕಂಥ ಡಾಕ್ಟರ್ ನಾಡಗೌಡರಿಗೆ ನಾನು ಪ್ರತಿಷ್ಠಾನದ ಪರವಾಗಿ ಸ್ವಾಗತವನ್ನ ಕೋರುತ್ತೇನೆ. ಧನ್ಯವಾದಗಳು ಸರ್. ವೆಲ್ಕಮ್.
ಇಂದಿನ ನಮ್ಮ ಕಾರ್ಯಕ್ರಮದ ಅತಿಥಿ ಉಪನ್ಯಾಸಕರನ್ನು, ಅಧ್ಯಕ್ಷರನ್ನು ಪರಿಚಯ ಮಾಡಿಸಿದ ಶ್ರೀ ಮಹದೇವಯ್ಯ ಕರ್ದಳಿ ಅವರಿಗೆ ಧನ್ಯವಾದಗಳು. ಇಂದಿನ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಮುಖ್ಯ ಉಪನ್ಯಾಸ ನೀಡಲು ಆಗಮಿಸಿದ ವಿಶ್ರಾಂತ ಪ್ರಿನ್ಸಿಪಲ್ ಜಿಲ್ಲಾ ಮತ್ತು ಸತ್ರ ನ್ಯಾಯಾಧೀಶರಾಗಿದ್ದ ಶ್ರೀ ಡಿ.ಆರ್. ವೆಂಕಟ ಸುದರ್ಶನ್ ರವರನ್ನು ತಮ್ಮ ಉಪನ್ಯಾಸ ನೀಡಬೇಕೆಂದು ವಿನಂತಿಸುತ್ತೇನೆ. ಬೇರೆಯವರೆಲ್ಲರೂ ತಮ್ಮ ವಿಡಿಯೋವನ್ನ ಆಫ್ ಇಟ್ಟು ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಂಡಿಡ್ಬೇಕಂತ ವಿನಂತಿ. ಸ್ಪೀಕರ್ ಮತ್ತೆ ಗೆಸ್ಟ್ ಮಾತ್ರ ಮ್ಯೂಟ್ ಮಾಡಿ ಇರಬೇಕು ಅಂತ. ಪ್ರಶ್ನೆಗಳನ್ನ ಕೇಳಬೇಕಾದ್ರೆ ಕೊನೆಯಲ್ಲಿ ಸ್ಪೀಕರ್ ಅವರು ಅನುಮತಿ ಕೊಟ್ರೆ ನಾವು ಪ್ರಶ್ನೆ ಕೇಳಬಹುದು. ಅವಾಗ ಮಾತ್ರ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೋಬಹುದು.
ಸರ್, ಕನ್ನಡ ಮತ್ತು ಇಂಗ್ಲಿಷ್ ಅಲ್ಲಿ ಮಿಕ್ಸ್ ಮಾಡಿ ಹೇಳ್ಬೇಕು ಸರ್. ಸೆಂಟ್ರಲ್ ಯೂನಿವರ್ಸಿಟಿ ವಿದ್ಯಾರ್ಥಿಗಳು, ಬೇರೆ ಸ್ಟೇಟ್ ವಿದ್ಯಾರ್ಥಿಗಳಿದ್ದಾರೆ. 2 ಭಾಷೆಯಲ್ಲಿ ಒಟ್ಟೊಟ್ಟಿಗೆ ಇದು ಮಾಡಿ ಸರ್. ಧನ್ಯವಾದಗಳು.
Thank you. Thank you very much, sir. Thank you. ಧನ್ಯವಾದಗಳು, sir. Good evening to one and all. ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. Respected Professor Dr. Sudarshan Nadgowder, sir, the Acting Vice Chancellor of the Karnataka State Rural Development and Panchayat Raj University. Respected Shri Basavaraj M. Kabakadi, sir, Deans, School of Legal Jurisprudence Studies, Central University of Karnataka. Respected Shri Amit Deshpande, the learned senior advocate and the trustee of this Pratishtana. Shri S.C. Patil, trustee of this Pratishtana, for all the coordinators also, and Shri Mahadevaya of Vignaneshwara Pratishtana, the young advocates, beloved law students, and all other respected persons who have all participating in this lecture series in order to take the benefit of the same. At the outset, I heartfully congratulate with a deep appreciation the organization of Vigneshwara Pratishtana Trust, the Department of Law, Central University of Karnataka, Kalaburgi, and Karnataka State Law University, Hubli, for having organized jointly this online lecture series to commemorate the pious occasion of 94th birth anniversary of the great legal luminary, Honorable Mr. Justice Dr. M. Rama Joyce, organized for the benefit of the members of the legal fraternity. I sincerely thank with deep gratitude to all the organizers of this Vignaneshwara Pratishtana Trust, Department of Law, Central University, and also Karnataka State Law University for having been kind enough to provide me an opportunity to participate in this lecture series organized to commemorate the 94th birth anniversary of the great soul, a scholar and a founder of this Pratishtana, Honorable Mr. Justice Dr. M. Rama Joyce, a legal luminary, and to deliver lecture on one important branch of law, that is the law of limitation. I consider this as blessings showered upon me by God. Thank you, sirs. By the grace of God, I had the great opportunity of visiting thrice Pratishtana at Kalaburgi, which according to me is a great place for learning and acquiring knowledge. That was once when I was a special judge at Kalaburgi during 2009 and 2011. Secondly, when I was the principal district and session judge at Kalaburgi during 2013 and 15. And on the third time, when I had an occasion to visit Central University, Kalaburgi, I had a wonderful opportunity of visiting this place and had received the hospitality of Shri Amit Deshpande, sir, the learned senior advocate. Then we had discussed about the various aspects concerning law. Again, I have been provided with an occasion of being present in this beautiful evening on this platform. Thank you. Thank you to all the concerned and the Pratishtana. Now, the subject that is slated for today's discussion is the law relating to limitation. The Limitation Act of 1963 is, although looks like a very small enactment containing only 32 sections, its impact is very vast. Its magnitude is great. A lawyer practicing on a civil side and a judicial officer presiding over a civil court will not be able to discharge their respective duties unless they are thorough with the provisions of the Limitation Act. Therefore, the provisions of the Act for no reason should be ignored or should be refused to look into merely because its size is very small. The first and the foremost aspect that I would like to touch upon is, where is the need for this Act? Why was this Limitation Act? Why should this Limitation Act at all? According to me, I judge it from three angles or three dimensions. One from the point of view of the plaintiff, another from the point of view of the defendant, and the third from the point of view of the state. We have all heard of an adage or a Latin phrase, a legal phrase, ubi jus, ibi remedium, which means where there is a right, there should be a remedy. A right without remedy is of no use. It is important for the credibility of the legal system, and it provides a remedial mechanism to implement rights and obligations. Therefore, where there is a right, there should be a remedy. If I am the owner of a property, it is my duty to protect the property securely, safely, and enjoy the property to the maximum possible extent, subject to the limitations relating to the law, if any, prevailing. If anybody tries to interfere with my right or infringes upon my right, I should have a remedy to seek redressal of the same. If there is no remedy at all, then there is no point in having a right. Now, if I have a right to seek a remedy, the question is, for how long a period, within how long a period I can seek that remedy. ನನಗೆ ಯಾವುದೇ ಒಂದು ಆಸ್ತಿ ಮೇಲೆ ಹಕ್ಕಿದ್ದಾಗ, ನಾನು ಮಾಲೀಕನಾಗಿದ್ದಾಗ, ಆ ಒಂದು ಆಸ್ತಿಯನ್ನ ನಾನು ನನಗೆ ಬೇಕಾದ ರೀತಿಯಲ್ಲಿ ಕಾನೂನಿನ ಚೌಕಟ್ಟಿನಲ್ಲಿ ಅನುಭವಿಸ್ತಕ್ಕಂಥ ಅಧಿಕಾರ ಮತ್ತು ಆ ಆಸ್ತಿ ಮೇಲೆ ಸಂಪೂರ್ಣ ಮಾಲೀಕತ್ವ, ಅದನ್ನು ನಾನು ಬೇಕಾದವರಿಗೆ ಮಾರ್ತಕ್ಕಂಥದ್ದು, ದಾನ ಮಾಡ್ತಕ್ಕಂಥದ್ದು, ಅಥವಾ ವಿಲ್ ಬರೀತಕ್ಕಂಥದ್ದು, ಅಥವಾ ಭೋಗ್ಯ ಮಾಡ್ತಕ್ಕಂಥದ್ದು, ಬಾಡಿಗೆ ಕೊಡ್ತಕ್ಕಂಥದ್ದು, ಸಂಪೂರ್ಣ ಹಕ್ಕು ನನಗಿರುತ್ತೆ. ಅಂತಹ ಹಕ್ಕಿಗೆ ಯಾರಾದ್ರೂ ತೊಂದರೆ ಕೊಟ್ಟಾಗ ಅಥವಾ ನನ್ನ ಆಸ್ತಿ ಮೇಲೆ ಯಾರಾದ್ರೂ ಇಂಟರ್ಫಿಯರ್ ಆಗಿ ಬಂದಾಗ ನನಗೆ ನನ್ನ ಹಕ್ಕನ್ನು ಕಾಪಾಡಿಕೊಳ್ಳೋದಕ್ಕೆ ಒಂದು ದಾರಿ ಇರಬೇಕು, ರೆಮಿಡಿ ಇರಬೇಕು. ಅಂತಹ ರೆಮಿಡಿ ಇಲ್ಲ ಅಂತಂದ್ರೆ ಅಂತಹ ಹಕ್ಕಿದ್ದು ಪ್ರಯೋಜನವಿಲ್ಲದೆ ಹೋಗುತ್ತೆ ಮತ್ತು ಲೀಗಲ್ ಸಿಸ್ಟಮ್ ಮೇಲೆ ಕ್ರೆಡಿಬಿಲಿಟಿ ಹೊರಟೋಗುತ್ತೆ. ಈ ಕಾರಣದಿಂದ ಈ ಒಂದು ಇಂಗ್ಲಿಷ್ ಅಡೇಜ್ ಏನಿದೆ, ಯು ಬಿ ಜಸ್ ಇ ಬಿ ರೆಮಿಡಿಯಂ, ಎಲ್ಲಿ ವೇರ್ ದೇರ್ ಇಸ್ ಎ ರೈಟ್ ದೇರ್ ಇಸ್ ಎ ರೆಮಿಡಿ, ಹ್ಯಾಸ್ ಟು ಬಿ ಲುಕ್ಡ್ ಇನ್ ಟು. ಹಾಗಂತ ಹೇಳಿ ರೈಟನ್ನ ಉಳಿಸ್ಕೊಳ್ಳೋದಕ್ಕೆ, ನನ್ನ ರೈಟಿಗೆ ತೊಂದರೆ ಬಂದಾಗ ನನಗೆ ರೆಮಿಡಿಗೆ ನಾನು ಹೋಗ್ಬೇಕು, ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹೋಗ್ಬೇಕು ಅಂದ್ರೆ ಯಾವ ಕಾಲದವರೆಗೂ, ಎಷ್ಟು ವರ್ಷಗಳವರೆಗೂ, ಎಷ್ಟು ತಿಂಗಳವರೆಗೂ, ಎಷ್ಟು ದಿವಸದವರೆಗೂ ಅಂತಹ ಹಕ್ಕಿರುತ್ತೆ ನನಗೆ? ಅಥವಾ ಕಂಟಿನ್ಯೂಸ್ ಆಗಿ ಅದೇ ಅಂತಹ ಹಕ್ಕು ಕಂಟಿನ್ಯೂಸ್ ಆಗಿ ಇರುತ್ತಾ ಅಂತಕ್ಕಂತಹ ಪ್ರಶ್ನೆ ಬಂದಾಗ ಲಿಮಿಟೇಷನ್ ಆಕ್ಟ್ ನಾವು ನೋಡ್ಬೇಕಾಗುತ್ತೆ. ಪ್ಲೈಂಟಿಫ್ ಪಾಯಿಂಟ್ ಆಫ್ ವ್ಯೂ ಇಂದ ಬಂದಾಗ, when I have a right, it is my duty to preserve it safely, protect it, and see that nobody interferes with my right. And if anybody interferes with my right, I must immediately rise to the occasion and approach the court of law for redressal. ಯಾರೇ ನನ್ನ ಹಕ್ಕಿಗೆ ಚ್ಯುತಿ ತಂದಾಗ, ನನ್ನ ಆಸ್ತಿ ಮೇಲೆ ಅತಿಕ್ರಮ ಪ್ರವೇಶ ಮಾಡಕ್ಕೆ ಪ್ರಯತ್ನ ಪಟ್ಟಾಗ, ನಾನು ಅದನ್ನು ತಡೆಯೋದಕ್ಕೋಸ್ಕರ ಸಾಧ್ಯವಾದಷ್ಟು ಬೇಗ ಕ್ಷಿಪ್ರವಾಗಿ ನ್ಯಾಯಾಲಯವನ್ನು ನಾನು ತಲುಪಬೇಕು. ನಾನು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹೋಗೋದನ್ನೇ ತಡ ಮಾಡಿದಾಗ, ವಿನಾಕಾರಣ ಅನವಶ್ಯಕವಾಗಿ ಯಾವುದೇ ಕಾರಣಗಳಿಂದ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹೋಗೋದನ್ನೇ ತಡ ಮಾಡಿದಾಗ, the law will not help me. That means the law will help the person who is diligent, who is vigilant, and does not help a person who is negligent and who will be neglecting his rights or sleep over rights for any length of time. Therefore, the person who has got a right should immediately act whenever there is an interference or a threat to his right. That is what is called, what we say, the law will protect a person who is diligent and not a person who is negligent or indolent. So this is from the point of view of the plaintiff to say that the plaintiff must approach the court within a reasonable time. From the point of view of the defendant, if we were to say, the defendant cannot be allowed to remain or live having a Damocles sword hanging on his head, thinking or apprehending that a litigation would be launched against him at any point of time. There should be an end for a particular action to be taken by the opposite party against another. That is why the Limitation Act is called as a statute of peace. So once a particular period stipulated in the act is over, the person who has got a right will lose the remedy. And sometimes it also so happens that on account of delay, there is every possibility of defendant losing the valuable evidence, both documentary and oral, on account of lapse of time. In such a case, the defendant may not be in a position to defend his case properly before the court of law if there is no limitation prescribed. This is from the defendant's point of view. From the state's point of view, it is the duty of the state to see. It is the duty of the state to see that any dispute with regard to the litigation should be put at rest. There should be a quietus after a reasonable time. If that is not prescribed, or if it is not provided, and if any party could approach the court after any length of time, and by any generation, then there will be no end at all. If that is permitted, even the disputes which have arisen during our forefathers' period will land in courts even today by way of litigation. If that is allowed to be done, any number of courts, any number of judicial officers, any amount of infrastructure, any amount of staff will not at all be sufficient, and the entire exchequer money will have to be spent for this, and the courts will have to involve themselves in dealing with those such stale old cases. Therefore, in order to bring quietus to such a dispute, a reasonable period of time has to be prescribed, even from the point of view of the state. In this context, I am drawing a judgment of the Honorable Supreme Court, reported in 2014, volume number 1, Karnataka Law Journal, page 34, Supreme Court, Basavaraj and another versus Special Land Acquisition Officer. I am drawing the attention of the learned persons here to para 13 of the judgment, wherein it reads as follows. The statute of limitation is founded on public policy. Its aim being to secure peace in the community, to suppress fraud and perjury, to quicken the diligence, and to prevent oppression. It seeks to bury all acts of past which have not been agitated unexplainably and have from lapse of time become stale. I am repeating this sentence again. It seeks to bury all acts of the past which have not been agitated unexplainably, ಯಾವುದೇ ಸಕಾರಣವಿಲ್ಲದೆ ಹಿಂದೆ ಉದ್ಭವಿಸಿರ್ತಕ್ಕಂತಹ ತಕರಾರುಗಳನ್ನ ಸೂಕ್ತವಾದ ಸಮಯದಲ್ಲಿ ನ್ಯಾಯಾಲಯಕ್ಕೆ ತೆಗೆದುಕೊಂಡು ಪರಿಹಾರ ಕಂಡುಕೊಳ್ಳದೇ ಇದ್ದರೆ ಅಂತಹ ಪ್ರಕರಣಗಳಿಗೆ ಇತಿಶ್ರೀಯನ್ನ ಹಾಡಬೇಕು. It should be buried. And because they have become stale on account of lapse of time. ವರ್ಷಗಳು ಕಳೆದಿರೋದ್ರಿಂದ ಅಂತಹ ವಿವಾದಗಳು ಹಳತಾಗ್ಬಿಟ್ಟಿರುತ್ತೆ. It becomes stale. According to Halsbury's Law of England, volume 24, page 181, quote, Policy of Limitation Acts. The courts have expressed at least 3 different reasons supporting the existence of statutes of limitation. Namely, number 1, that long dormant claims have more of cruelty than justice in them. Number 2, a defendant might have lost the evidence to disprove a stale claim. Number 3, a person with good causes of action should pursue them with reasonable diligence. That's what I said. The law will help a person who is diligent and not a person who is negligent and who has slept over his rights when that is being interfered by others. An unlimited limitation would lead to a sense of insecurity and uncertainty, and therefore limitation prevents disturbance or deprivation of what may have been acquired, inequity and justice by long enjoyment, or what may have been lost by a party's own inaction, negligence, or laches. I stop at this so far as this judgment of the Supreme Court is concerned. So this judgment of the Supreme Court says about the need for a limitation act. Why a limitation act should be there, and what is the importance of this limitation act, and how a person who is diligent will have to seek remedy before the court of law, and within what particular period of time. And on the same principle, there is one more judgment of the Honorable Supreme Court reported in AIR 1972 Supreme Court, page 1935, page 1935. BB&D Manufacturing Company versus ESI Corporation. And AR 2018, a full bench judgment of the Delhi High Court, page 146. And there are a number of judgments on this aspect. Now, whenever a suit is to be filed before a court, one of the important aspects that an advocate is expected to find out or ascertain is the limitation with reference to the relief that is sought to be claimed. So for that, a separate para also will have to be reserved in the plaint, and it should be shown by the plaintiff as to why and how that the suit brought before the court is well within the period of limitation. It is in this context that I say that an advocate should be thorough with the provisions of the Limitation Act. As I have already stated, Limitation Act is a very small enactment containing only 36 sections. But its significance is very vast, and it is the most important legislation. Whenever we have got to look into an enactment, in my opinion, two important things are to be noted. One is the preamble, another one is the definition clause. The preamble portion of the act will have to be looked into in order to ascertain scope, object, and nature of the act and the purpose for which it has been brought into force, and the methodology in which the purpose is going to be, the goal is going to be achieved. ಯಾವುದೇ ಒಂದು ಅಧಿನಿಯಮವನ್ನು ನಾವು ಓದಬೇಕಾದ್ರೆ ಮೊಟ್ಟ ಮೊದಲನೇದಾಗಿ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಓದಬೇಕು. ಯಾಕೆಂದ್ರೆ ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ಆ ಒಂದು ಅಧಿನಿಯಮದ ವ್ಯಾಪ್ತಿ, ಅದರ ಸ್ವರೂಪ ಮತ್ತು ಅದರ ಅಪ್ಲಿಕೇಶನ್ ಬಗ್ಗೆ ಹೇಳಿರ್ತಾರೆ, ಮತ್ತು ಅದರ ಒಂದು ಗುರಿ ಏನಿದೆ, ಆ ಒಂದು ಅಧಿನಿಯಮದ ಗುರಿ, ಆ ಗುರಿಯನ್ನು ತಲುಪತಕ್ಕಂತಹ ವಿಧಿವಿಧಾನಗಳ ಬಗ್ಗೆನೂ ಹೇಳಿರ್ತಾರೆ. ಆದ್ರಿಂದ ಯಾವುದೇ ಒಂದು ಅಧಿನಿಯಮವನ್ನು ನಾವು ಓದಬೇಕಾದ್ರೆ ಮೊದಲು ಪ್ರಸ್ತಾವನೆಯನ್ನು ಓದಬೇಕು. ಅದೇ ರೀತಿ ಡೆಫಿನಿಷನ್ ಕ್ಲಾಸ್ ಬಹಳ ಇಂಪಾರ್ಟೆಂಟ್. ವೈ? ಬಿಕಾಸ್ certain words and phrases which are used in that particular act will have to be understood only in the manner that is defined in that act. We cannot give any other meaning. It so happens that the same word will have different meaning under different context and in different enactments. Therefore, what is the meaning or the definition that has been given to a particular word or a phrase that is used in that act will have to be understood only in terms of the meaning that is assigned in the definition clause. Insofar as the Limitation Act is concerned, I am only drawing the attention to four important definitions. Four important definitions. And before that, the Limitation Act contains two parts. One is the substantive part, another one is the, rather I can say, a procedural part. The substantive part contains only section 1 to 32. But in the table that is found in the form of a schedule to the Limitation Act, which is found after 32 sections, we have three columns. Number one, nature of the suit. Number three, period of limitation. Number two, period of limitation. Number three, the time from which the limitation starts. So we have 137 articles in the schedule and 1 to 32 sections in the sections part. In that 137 schedules, there are three parts. One is from article 1 to 113, which deals with the different types of suits, the limitation prescribed for them, and the time from which the limitation would start. And article 114 to 117 deals with appeals. And article 118 to 137 deals with applications. So there are three parts: suits, appeals, and applications. Further, in my opinion, the Limitation Act is applicable for civil cases, except except there are three articles, 114, 115, and 132, except these three articles which are applicable for criminal cases also, which deals with appeal against acquittal, appeal against conviction, appeal against revision. All other sections, almost all other sections are applicable largely for the civil cases only. This is another important aspect which has to be kept in mind. Coming to the definition part, there is one important definition which has to be kept in mind when we are reading the different sections of the Act. ನಾವು ಈ ಕಾನೂನು ಪುಸ್ತಕವನ್ನ 32 ಸೆಕ್ಷನ್ಗಳನ್ನ ಓದುವಾಗ ಎರಡು ಇಂಪಾರ್ಟೆಂಟ್ ಡೆಫಿನೇಷನ್ಸ್ ನ ಜ್ಞಾಪಕ ಇಟ್ಕೋಬೇಕು. ಏನು? ಪೀರಿಯಡ್ ಆಫ್ ಲಿಮಿಟೇಷನ್ ಅಂಡ್ ಪ್ರಿಸ್ಕ್ರೈಬ್ಡ್ ಪೀರಿಯಡ್ ಆಫ್ ಲಿಮಿಟೇಷನ್. There are two things, period of limitation and prescribed period of limitation. What do you mean by period of limitation? Period of limitation means the limitation period prescribed in the schedule appended to the Limitation Act. Prescribed period of limitation means the limitation period computed as per the provisions of the Act. How? We will see later. So this is one important thing that has to be kept in mind. Then there is the meaning of the word due diligence. The word due diligence is used in the Limitation Act. The due diligence, dealing with the word due diligence, the Honorable Supreme Court in 2008, Volume 7, SCC 169 has stated that due diligence cannot be measured by any absolute standards. It is a measure of prudence or activity expected from an ordinarily exercisable by a reasonable man or a prudent person under the particular circumstances. ಸಾಮಾನ್ಯ ಜ್ಞಾನ ಇರತಕ್ಕಂತಹ ವ್ಯಕ್ತಿ ಯಾವುದೇ ಒಂದು ಸಂದರ್ಭದಲ್ಲಿ ಯಾವ ರೀತಿ ವರ್ತಿಸ್ತಾನೆ, ಸಾಮಾನ್ಯವಾಗಿ ವರ್ತಿಸ್ತಾನೆ ಅಂತಕ್ಕಂಥದ್ರ ಆಧಾರದ ಮೇಲೆ ಡ್ಯೂ ಡಿಲಿಜೆನ್ಸ್ ಆತರ ವರ್ತಿಸಿದಾನ ಇಲ್ವಾ, whether he was diligent or not. So that on that basis it will be decided. Another one is good faith. This word is also used in Limitation Act. Good faith means want of care and attention. And there is no hard and fast rule which defines what good faith is. Again, that depends upon the facts and circumstances of each case. So these are the two important definitions which are to be kept in mind. There are a number of other definitions also, but I am concentrating for this session only with these two definitions. Now, coming to the section part. Section 3 of the Limitation Act is a very important section. If we understand Section 3 of the Limitation Act properly, perhaps we will be in a position to understand the remaining sections very easily. This is my opinion. Why? How it is so relevant. Section 3 of the Limitation Act says, subject to the provisions from Section 4 to Section 24, subject to the provisions from Section 4 to Section 24, suit filed, appeal preferred, application made after the period of limitation shall be dismissed by the court, even though there is no defense raised to that effect. I request to note the mandate of this section. Court has been mandated, court has been obligated under this section to dismiss a suit, to dismiss an appeal, to dismiss an application if it is filed after the period of limitation, even though the other side has not taken defense. Which means to say, even if the defendant has not raised any objection in the written statement, or even though the respondent has not raised any objection with regard to the case being barred by limitation, or application being barred by limitation, or appeal being barred by limitation, it is the duty of the court to examine whether the appeal or application or a suit filed before it is well within the period of limitation or barred by limitation. ಯಾವುದೇ ಒಂದು ದಾವೆಯನ್ನಾಗಲಿ, ಮೇಲ್ಮನವಿಯನ್ನಾಗಲಿ ಅಥವಾ ಅರ್ಜಿಯನ್ನಾಗಲಿ ಕಾಲ ಪರಿಮಿತಿ ಅವಧಿಯ ನಂತರ, ಲಿಮಿಟೇಷನ್ ಆಕ್ಟ್ ಮೀನ್ಸ್ ಕಾಲ ಪರಿಮಿತಿ ಅಧಿನಿಯಮ, ಕಾಲ ಪರಿಮಿತಿ ಅವಧಿಯ ನಂತರ ದಾಖಲು ಮಾಡಿದ್ದರೆ ಅಂತಹ ದಾವೆಯನ್ನ, ಅಂತಹ ಮೇಲ್ಮನವಿಯನ್ನ, ಅಂತಹ ಅರ್ಜಿಯನ್ನ ಎದುರುದಾರ ಅದರ ಬಗ್ಗೆ ತಕರಾರು ಎತ್ತಿರದೇ ಇರಲಿ, ನ್ಯಾಯಾಲಯ ವಜಾ ಮಾಡಲೇಬೇಕು. ಕೋರ್ಟ್ ಶಲ್. ಬಟ್ ಬಿಗಿನಿಂಗ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ, ಸಬ್ಜೆಕ್ಟ್ ಟು ದಿ ಪ್ರಾವಿಷನ್ಸ್ ಕಂಟೈನ್ಡ್ ಫ್ರಮ್ ಸೆಕ್ಷನ್ 4 to section 24. ಅಂದ್ರೆ ಏನು? ಈ ಅಧಿನಿಯಮದ ಕಲಂ 4ರಿಂದ 24ರಲ್ಲಿ ಹೇಳಿರ್ತಕ್ಕಂತಹ ಸಂದರ್ಭಗಳಿಗೆ ಹೊರತಾಗಿ, subject to the provisions contained therein, any suit filed, any appeal preferred, any application made after the period of limitation shall be dismissed. So that means if a party takes a shelter under any of the provisions from section 24 to 24 as may be applicable to him in a given case, if no such shelter is taken under any of these provisions, and if it is apparently barred by limitation, then it shall be dismissed. The plaintiff cannot say, Your Honor, the defendant has not taken a plea that the suit is barred by limitation, therefore this court cannot look into. Defendant cannot say that, because court is mandated to look into it whether the suit is barred by limitation or not. So this is the importance of section 3. So section 3, if it is read along with section 4 to 24, according to me, we will be able to understand the Limitation Act fully. In this context, the Honorable Supreme Court in its judgment reported in AIR 2008, Supreme Court 911, Section 3. And there is also another judgment, 2012, Volume 3, KCCR 2063. What does the Supreme Court judgment says? Section 3 of the Act, I am reading the para from the Supreme Court judgment. Section 3 of the Act mandates, I am emphasizing the word mandates, that a court would not exercise jurisdiction for any relief in favor of a party if the same is found to be barred by limitation. Although such a defense has not been raised, the statute obligates upon the court of law to consider whether a suit is barred by the limitation or not. In the event it was found that the suit was barred by limitation, the court had no jurisdiction to pass a decree. So this judgment clearly shows that the court has been mandated under the provisions of Section 3, and it is obligatory on the part of the court to compulsory go into the every suit or appeal or application file to consider whether that suit or appeal or application has been filed well within the period of limitation. So this is the importance of Section 3 of the Limitation Act. There are a number of judgments on this particular point, and because of the paucity of time, I have referred only to one judgment of the Supreme Court. Now, Section 4, as I have already said, says that, Section 3. Section 3, I have already said that, subject to the provisions from Section 4 to 24, which means to say, if the plaintiff, or if a party, rather we'll put it like that, if a party is taking shelter under any of the provisions from Section 4 to 24 as a cause for bringing the suit or application or appeal after the limitation period prescribed in the schedule, then that plea taken by the party will have to be considered by the court. Once again, I am repeating. ಸೆಕ್ಷನ್ ಕಲಂ 4ರಿಂದ 24ರಲ್ಲಿ ಹೇಳಿರ್ತಕ್ಕಂತಹ ಸಂದರ್ಭಗಳ ಆಧಾರದ ಮೇಲೆ ಯಾವುದೇ ಪ್ರಕರಣದಲ್ಲಿರ್ತಕ್ಕಂತಹ ಪಕ್ಷಕಾರರು ವಿಳಂಬಿತವಾಗಿ ತಂದಿರತಕ್ಕಂತಹ ದಾವೆಗೆ ಅಥವಾ ಮೇಲ್ಮನವಿಗೆ ಅಥವಾ ಅರ್ಜಿಗೆ ಕಾರಣ ಎಂದು ಹೇಳಿದ್ದರೆ ಅಂತಹ ಸಂದರ್ಭದಲ್ಲಿ ಆ ಒಂದು ಸೆಕ್ಷನ್ 4ರಿಂದ 24ರಲ್ಲಿ ಯಾವ ಸೆಕ್ಷನ್ ಅಡಿಯಲ್ಲಿ ಆ ಪಕ್ಷಗಾರ ಶೆಲ್ಟರ್ ತಗೊಂಡಿರ್ತಾನೆ, ರಕ್ಷಣೆ ತಗೊಂಡಿರ್ತಾನೆ, ಅದು ಸ್ಯಾಟಿಸ್ಫೈ ಆಗಿದೆಯಾ ಇಲ್ವಾ ಅನ್ನೋದನ್ನ ನೋಡ್ಬೇಕು. ಅದು ಸ್ಯಾಟಿಸ್ಫೈ ಆಗಿದ್ರೆ ಆವಾಗ ಶೆಡ್ಯೂಲ್ ಅಲ್ಲಿ ಹೇಳಿರ್ತಕ್ಕಂಥ ಲಿಮಿಟೇಷನ್ ಪೀರಿಯಡ್ ಆದ್ಮೇಲೆ ಹಾಕಿದ್ರು ಸಹ ಅಂತದನ್ನ ಪರಿಗಣಿಸಬಹುದು, ಇಲ್ಲದೆ ಇದ್ರೆ ಇಲ್ಲ. ಸೊ ದಿಸ್ ಈಸ್ ಹೌ ಅಕಾರ್ಡಿಂಗ್ ಟು ಮೀ ಸೆಕ್ಷನ್ 3 will have to be understood. Now we will see from section 4 to section 24. 4 to 24 ಆಗಲ್ಲ ಇವತ್ತು, ನೋಡೋಣ, ಒಂದು 5-6 ಸೆಕ್ಷನ್ ಮಾಡ್ಲಿಕ್ಕಾದ್ರೆ ನೋಡೋಣ. ಸಿ section 4 to section 24 ಅಲ್ಲಿ we will see how many sections we will be able to do it today. Section 4 of the Limitation Act says that where on the date on which the limitation period expires, on the date on which the limitation period expires, if the court is closed, then the limitation period extends to the next immediate working day. ಯಾವತ್ತಿನ ದಿವಸ ಕಾಲ ಪರಿಮಿತಿ ಅವಧಿ ಕೊನೆಗೊಂಡಿರುತ್ತೋ ಆವತ್ತಿನ ದಿವಸ ನ್ಯಾಯಾಲಯ ರಜೆ ಇದ್ದರೆ ಆಗ ಆ ಲಿಮಿಟೇಷನ್ ಪೀರಿಯಡ್ ನೆಕ್ಸ್ಟ್ ಯಾವತ್ತಿನ ದಿವಸ ನೆಕ್ಸ್ಟ್ ವರ್ಕಿಂಗ್ ಡೇ ಇರುತ್ತೆ ಅಲ್ಲಿಗೆ ಮುಂದೂಡಲಾಗುತ್ತದೆ. Let us take an example to understand this. For example, X has taken loan from Y on 1/1/2020 and executed a promissory note agreeing to repay the loan on demand. So the plaintiff makes a request demanding repayment of the money. The defendant does not repay. So such repeated requests are also made. Even then the defendant did not pay. Then the plaintiff has issued a legal notice to the defendant on a particular day. Even then the defendant did not respond. So plaintiff has a right to collect that money back from the defendant on the strength of the pro note. So when he has got that right, remedy is always there for him to go to the court of law and file a suit against the defendant against Y for recovery of the money. The Limitation Act says, the schedule, that the period of limitation is 3 years from the date of execution of the pro note. Pro note was executed on 1/1/2020. 3 years come to end by 31st of December 2022. So the plaintiff has to file a suit within the last date of 31/12/2022. So the plaintiff prepares a suit and comes to the court on 31/12/2022. On that day, the court is closed because it is a general holiday or declared a general holiday, or it was a Sunday or some such thing. Therefore, the plaintiff could not file a suit on that day in the office because the office is closed, the court is closed. But that is the last date of limitation. In usual course, if that is not filed on that day, the plaintiff will be deprived from filing a suit on 1st of January. Even if he files it, it will have to be dismissed. But because 31st of December 2022 happens to be a general holiday, and the court was closed. And of course, in Karnataka, all of us know that on 31st of December 2022, the courts are closed, civil courts are closed because of a winter vacation. So thereby, the plaintiff is precluded from filing a suit on the day, not for his fault, but because of the reasons beyond his control. Under such circumstances, the limitation period extends to the next working day in the sense, for example, 1st January is also a holiday. It declared as a holiday because of the New Year's Day. Then 2nd January. If 2nd January is a Sunday, then Monday. So this is the spirit of Section 4. That is, Section 4 says that whereas on the date on which the limitation period expires, to file a suit or an appeal and application for the reason that the court was closed, then the limitation period extends to the next working day, to the immediate next working day. Supposing if 2nd is Monday and 31st and 1st were general holiday, and if he doesn't file a suit on Monday, he will lose the right forever. In case of a suit, he will lose the right forever. He cannot file a suit at all. He will be debarred from filing a suit because the remedy is gone. So this is how Section 4 will have to be interpreted. So as an advocate, what we have to do? As an advocate, we have to, when we are presenting a plaint, for example, after the last date of limitation on the next working day, because it was a holiday on that date, you have to mention that in a para. How? The suit was to be filed on or before 31st of December 2012. That is the last date of limitation. However, the suit could not be filed on that day because it was a general holiday and the court was closed. Therefore, and first was also declared as a general holiday. 2nd was a Sunday. Therefore, I am filing this suit on the next immediate working day, that is Monday. Hence, in view of the provisions of Section 4 of the Limitation Act, the suit filed is well within the period of limitation. Of course, in the plaint, you need not plead the law. It is sufficient if you say, therefore, I have filed the suit on next immediate working day. Hence, the suit filed is well within the period of limitation. Why that para is required? That para is required because if you don't mention that in detail, the plaint will come for hearing, say, for example, a year or 2 years later. On that day, nobody will be knowing whether 31st December was a holiday or so. So the defendant may argue, look here, the suit is barred by limitation because the limitation period expired on 31st of December, but the suit is filed on 2nd January. In order to get rid of such a possible situation, it is always better to mention in the plaint as to why you are claiming that exemption period of 2 days in filing the suit. This is a very, very, very important aspect that the members of the profession will have to keep in mind. Then, so the main object behind this section is no person should be put to trouble or inconvenience because of the mistake of the court or because of the fault on the other side. There was no mistake on the part of the plaintiff. He was ready with the plaint. He has come to the court. He wanted to file a suit, but he could not do it because it was not for his mistake. It was because the court was closed. So it was for the reason beyond his control. Therefore, Section 4 comes in the way. A person cannot be asked to do something which he cannot do. Plaintiff could not at all have filed the suit on 31st December because it was a general holiday and the court was closed. Therefore, the limitation period extends to the next immediate working day. This is how, according to me, Section 4 will have to be invoked. Here, I would like to bring to the notice that is one more principle under the Limitation Act. What is it? The Limitation Act bars only the remedy but not the right. This is a very, very important concept under the Limitation Act. Limitation Act bars only the remedy but not the right. What does it mean? The meaning is Take the same example which I have given. On 1st of January 2020, X has borrowed money from Y, a sum of rupees 5,000. X has executed a pronote in favor of Y, agreeing to repay the same on demand. He doesn't pay. The last day of limitation is 31st December 2022. The plaintiff did not file suit at all. Even though 31st December was a general holiday, even on 2nd, the next immediate working day, he did not file a suit. So when he is barred from filing a suit because of the bar of limitation, he cannot file a suit on 3rd of January 2023 because it is barred by limitation. That means even if he files a suit on 3rd January 2023, the court will dismiss the suit as barred by limitation and it will not entertain the suit at all. That means the plaintiff cannot have a remedy before the court. So that is the meaning of saying the Limitation Act bars the remedy. What do you mean by but not the right? It bars only the remedy but not the right. Supposing after first week of January 2023, the defendant comes to the plaintiff, X goes to Y, X has borrowed money from Y, X goes to Y, and tenders money. Look here, I have borrowed money from you, and I am repaying this money along with the interest. Kindly accept it. Sorry for the delay. I could not make payment earlier. Though you have requested, though you have sent a notice. Now I received some money, and now I have cash with me. Please take it. Now the question is whether the plaintiff can refuse to receive the money because it is barred by limitation. The answer is no. Because the plaintiff has a right to receive the money since he has advanced the money. So the plaintiff can take money from Y, from the X can take, Y can receive money from X, even though it is barred by limitation, because he has a right to receive it. So right is not barred. Limitation Act bars only the remedy, but not the right. So he has a right, but he has a right to receive the money even after the period of limitation. But what is barred is a remedy before the court. He cannot go to the court and file a suit for recovery of the money because it is barred by limitation. So that is the concept, that is the meaning of the concept that Limitation Act bars only the remedy, but not the right. In this context, there was one judgment of the Honorable Supreme Court reported in AIR 1992 Supreme Court page 1815. That is Punjab National Bank versus Surendra Prasad Sinha. Here what happened was the defendant borrowed money from the plaintiff. I don't say defendant. X borrowed money from the bank and executed the necessary documents. And as a surety to X, A and B stood as a surety, and they deposited their fixed deposit receipt, which was for a sum of rupees 24,000 in the bank as a security for the loan advanced to X. X became a defaulter. He did not repay the loan. Bank also did not file any suit. Limitation period is over. So the bank has been deprived from filing a suit because the limitation period is over and the bank could not seek remedy before the court because Limitation Act bars remedy, but not the right. So what happened? After a few years, the fixed deposit receipt which was offered as a security with the bank matured. So the bank, from out of the proceeds of the fixed deposit receipt, appropriated the amount towards the loan payable by X, principal borrower, and credited the remaining amount only to the account of the surety. Surety objected for that on the ground when the period of limitation for recovery of the money from the principal debtor itself is barred, you could not have appropriated the money from the matured value of the FDR. Then the matter entered the litigation portals of the court. The matter went up to Supreme Court. It was decided that the bank was right in appropriating money from the proceeds of the fixed deposit, because what was borrowed was only a remedy, that is remedy to approach the court, but right to recover money is not borrowed. Now, since these two persons were the surety for the principal debtor, and the fixed deposit receipt was offered as a surety, the bank could always recover it because it has a lien over it. So this is how we can understand that the Limitation Act bars only the remedy, but not the right. So this is so far as Section 4 is concerned. Now we will move on to Section 5. Section 5, I hope almost all the advocates are very much familiar with this, because day in and day out we will be filing such application in one or the other case, other cases or appeals or application or appeals. What does Section 5 says? Section 5 of the Limitation Act says that where an application is filed, any appeal or application other than the application under Order 21 CPC is filed beyond the period of limitation may be admitted by the court if the appellant or the applicant shows sufficient cause for not preferring that appeal or application well within the period of limitation. ಯಾವುದೇ ಒಂದು ಮೇಲ್ಮನವಿ ಅಥವಾ ಅರ್ಜಿಯನ್ನ ಎಕ್ಸೆಪ್ಟ್ ಆರ್ಡರ್ 21 CPC ಬರ್ತಕ್ಕಂತಹ ಅರ್ಜಿಯನ್ನ ಬಿಟ್ಟು ಯಾವುದೇ ಒಂದು ಮೇಲ್ಮನವಿ ಅಥವಾ ಅರ್ಜಿಯನ್ನ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಕಾಲ ಪರಿಮಿತಿ ಅವಧಿ ಮೀರಿ ದಾಖಲು ಮಾಡಿದ್ದರೆ ಅಂತಹ ಮೇಲ್ಮನವಿಯನ್ನ ಅಂತಹ ಅರ್ಜಿಯನ್ನ ಸಲ್ಲಿಸುವಾಗ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಸಲ್ಲಿಸುವಾಗ ಆಗಿರತಕ್ಕಂತಹ ವಿಳಂಬಕ್ಕೆ ಸೂಕ್ತವಾದ ಕಾರಣವನ್ನು ನೀಡಿದ ಪಕ್ಷದಲ್ಲಿ ಸಫಿಷಿಯಂಟ್ ಕಾಸ್ ಸಮರ್ಪಕವಾದ ಕಾರಣವನ್ನು ನೀಡಿದ ಪಕ್ಷದಲ್ಲಿ ನ್ಯಾಯಾಲಯ ಅದನ್ನ ಒಪ್ಪಿ ತೆಗೆದುಕೊಳ್ಳಬಹುದು. Any appeal or application other than the application under Order 21 CPC, if filed after the period of limitation, may be entertained by the court if the appellant or the applicant shows sufficient cause for not preferring such application or appeal or application well within the period of limitation. Now, what is the concept of this? Number one, Section 5 is applicable only for appeals and applications. It does not apply to suits. Very important aspect to be kept in mind. One cannot file a suit once it is barred by limitation along with an application under Section 5 of the Limitation Act. So Section 5 of the Limitation Act is not applicable to the suits. That is to the plaint that is presented. It is applicable only to the appeals and applications. That too, what sort of applications? Other than the applications under Order 21. Order 21 deals with execution of the decree, CPC. So any application coming under the provisions of Order 21 CPC is not within the purview of Section 5 of the Limitation Act. So number one, it is not applicable for suits. Number two, it is not applicable for applications under Order 21. Number three, it is applicable only for appeals and applications, other appeals and applications, appeals and other applications. Number four, they must be presented after the period of limitation. Number five, there must be an application along with an affidavit, and in the affidavit, the appellant or the applicant must make out a ground which constitute a sufficient cause and convinces the court that the cause shown is sufficient, and it is only in such circumstance that the court will entertain that appeal or application. Now, so what the cause that the party is showing in the application filed along with the appeal or application should be sufficient. What do you mean by a sufficient cause? Sufficient cause cannot be defined in one word. It depends upon the facts and circumstances of each case, because every case is peculiar to the facts and circumstances of its own. We are all human beings. We will be placed in a very peculiar situation on different occasions. So whether the situation in which a man was placed at that particular time can only be decided by the facts and circumstances that were prevailing at that particular point of time. Therefore, again, I am drawing the attention to the same judgment which I have referred earlier, that is 2014, Volume 1, Karnataka Law Journal, page 34, to understand what sufficient cause is. In this judgment, the Honorable Supreme Court says that sufficient cause is the cause for which the defendant could not be blamed for his absence. What does it mean? If I am filing an appeal after the period of limitation, if I am presenting an application after the period of limitation, that delay should not be on account of my negligence. I should not be responsible for the delay that is caused. That delay must have been caused for the reasons beyond my control, for the reasons beyond my hand, for which I am not at all responsible. It is only that cause which can be said to be sufficient. To cite one or two raw examples. Today I have to file an appeal. Today is the last date to file an appeal. I have come to the bus stand to get into the bus in order to go to the town, to the court to file an appeal. But all of a sudden, there was a strike. All buses, playing of buses were stopped. All vehicles stopped. I could not get any conveyance to go to the city or the town where the court is situated, because there was big commotion, galata, everything. So I was practically prevented from traveling from the place where I was to the court. For that I am not responsible. Nothing was in my hands. The situation was beyond my control. So if that cause is shown as sufficient cause, and if that is established, the court would certainly, in my view, condone the delay and entertain the appeal or the application. This could be a sufficient cause, because the delay was on account of, not on account of me, it was on account of circumstances which were beyond my control. Number one. Number two, X had to go to town to file an appeal. All of a sudden, some of his family members suffered from critical illness. There was nobody else to take care of them. He has to take the responsibility of shifting that person to the hospital. He has to take the responsibility of taking care of him, provide medicines, go here and there to secure necessary items. And as a result, he could not go to the court for the purpose of filing an appeal. That could be a sufficient cause. Or if the party who has to go to and file an appeal himself fell sick, he was bedridden, he could not move out, he was not in a position to send message also to anybody, and if proper document is produced, that could be a sufficient cause. In all the three circumstances you see, the person who wanted to file an appeal or application was not at all, the delay was not on account of him at all. It was for the reasons beyond his control. He was not able to prevent it. It has occurred, therefore the delay. So sufficient cause means the cause which should be sufficient, for which the appellant or the applicant should not be responsible. In the same judgment, at para number 11, the Honorable Supreme Court has said, the expression sufficient cause should be given a liberal interpretation to ensure that substantial justice is done. But this is very important. Only so long as negligence, inaction, or lack of bona fides cannot be imputed to the party concerned, whether or not sufficient cause has been furnished can be decided on the facts of a particular case, and no straight-jacket formula is possible. So, sufficient cause if shown, and if the court is convinced that the delay was not on account of the party concerned, it was for the reasons beyond his control, and he had no hand in that, and he could not control the situation, and therefore the delay has caused, the court may condone the delay and entertain the appeal or the application. I am using the word may because even then the discretion whether to grant, whether to condone the delay or not to condone the delay is well within the court, within the powers of the court. The court has to exercise its judicial discretion and then will have to decide whether to condone the delay or not to condone the delay. In fact, the Honorable Supreme Court in one of the judgments has said that if a sufficient cause is shown, the length of delay is immaterial. There are cases where a delay of a short duration has not been condoned. Once again, I am repeating. There are cases where even a delay of short duration has not been condoned because the cause shown was not sufficient. There are instances where the long period of delay has been condoned because the cause shown was sufficient. So what all to be considered while filing an application under Section 5 of the Limitation Act, whether the cause that we are showing is a sufficient cause within the meaning of these decisions of the Supreme Court. A casual application cannot be filed under Section 5 and submit to the court that the court has to take liberal view, irrespective of the cause that you have shown. No. The law says, first of all, you must show the cause which is sufficient. That is, the delay was occurred not on account of you. You means the party. But the delay was occurred on account of the reasons beyond his control. Then you leave it to the court. The court will have to use the judicial discretion and decide whether to condone the delay or not. This is how Section 5 of the Limitation Act, according to me, will have to be interpreted. So there are umpteen number of decisions, but because of the want of time, I will not be able to place those decisions. But this is sufficient for the present to understand this much, according to me. Then, Section 6 of the Limitation Act. A very, very beautiful section it is, a wonderful section it is. What does Section 6 of the Limitation Act says? Where a person is entitled to file a suit. Kindly look at each and every word. Look at each and every word. Where a person is entitled to institute a suit or make an application for execution of a decree is suffering from any legal disability, such as a minor, a lunatic, or an idiot. The word is used, or an idiot. Then the limitation period does not run as long as he is suffering from that legal disability of minority, lunacy, or idiocy. Till when till the disability ceases. CEASES. ಯಾವುದೇ ಒಬ್ಬ ವ್ಯಕ್ತಿಗೆ ಒಂದು ದಾವೆಯನ್ನ ಹೂಡತಕ್ಕಂತಹ ಹಕ್ಕು ಬಂದಾಗ, ಎಂಟೈಟಲ್ ಟು ಫೈಲ್ ಎ ಸೂಟ್ ಹಕ್ಕು ಬಂದಾಗ, ಅಥವಾ ಡಿಗ್ರಿಯನ್ನ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡೋದಕ್ಕೆ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೋದಿಕ್ಕೆ ಹಕ್ಕು ಬಂದಾಗ, ಆತ ಮೈನರ್ ಆಗಿದ್ರೆ ಅಥವಾ ಲ್ಯೂನಟಿಕ್ ಆಡು ಭಾಷೆಯಲ್ಲಿ ಹುಚ್ಚನಾಗಿದ್ರೆ ಅಂತ ಇಟ್ಕೊಳ್ಳೋಣ, ಅಥವಾ ಇಡಿಎಸ್ಸಿ ಅಂದ್ರೆ ಹುಟ್ಟುದಡ್ಡನಾಗಿದ್ದರೆ, ಸೊ ಅವನಿಗೆ ಹಕ್ಕು ಬಂದಿದೆ. ಹಿ ಹ್ಯಾಸ್ ಟು ಫೈಲ್ ಎ ಸೂಟ್, ಹಿ ಹ್ಯಾಸ್ ಎ ರೈಟ್ ಟು ಫೈಲ್ ಎ ಸೂಟ್. ಇವತ್ತು ಬಂತು ಅವನಿಗೆ ಹಕ್ಕು, ಹಿ ಕ್ಯಾನ್ ಫೈಲ್ ಎ ಸೂಟ್. ಅಥವಾ ಇವತ್ತು ಅವನ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಬಹುದು. ಆದ್ರೆ ಇವತ್ತಿನ ದಿವಸದಿಂದ ಅವನು ಹಿ ಈಸ್ ಸಫರಿಂಗ್ ಫ್ರಮ್ ಎ ಲೀಗಲ್ ಡಿಸಬಿಲಿಟಿ. ಇವತ್ತಿನ ದಿವಸದಿಂದಲೇ. That is what we have to understand. Where, look at the section, where a person entitled to institute a suit. X is entitled to institute a suit, but he cannot institute a suit because he is a minor. He cannot institute a suit because he is a lunatic. He cannot institute because he is an idiot. Or nor he can file a petition for execution of a decree. Then whatever the limitation period that is prescribed under the schedule, it will not run. It will not run. It stops. Till when? Till the disability ceases. CEASES. What does it mean? That is, when a minor becomes a major, will a lunatic become a normal person? And an idiot also becomes a normal person. Till such time, his right is not lost, and the limitation will not start. So right will always be there protecting such persons. This is the law. That is how we have to interpret section 6 of the subsection 1 of the Limitation Act. So, in order to apply section 6, a person who is entitled to file a suit or make an application for execution of a decree must be suffering from any of these 3 disabilities. One or more, of course. One or more disabilities. So if he is suffering from such disabilities, his right to file a suit will be kept in abeyance, will be in abeyance. He will get that right when all these disabilities or his disability ceases. Subsection 2 says, where a person is suffering from a disability of a particular character, even before he becomes able, he is attacked with another disability. Then the law says, till both the disabilities ceases, limitation period will not run. Supposing a person who is aged about 16 years, he has a right to file a suit is accrued to him. He cannot file a suit because he was a minor. He is a minor. So limitation period will be in abeyance for 2 years till he completes 18 years of age. Now today he has attained 18 years of age, but unfortunately he has become a lunatic. So one disability ends, another disability starts. So the law says the limitation period will not run till both the disabilities ceases. This is another aspect. Third aspect, subsection 3. Where a person suffering from disability dies during the subsistence of the disability, then from that date onwards, his legal representatives will have the limitation period run, and they will get the period that is prescribed under the statute. X had a right to file a suit. He was a lunatic. And during the period of lunacy, he dies. Naturally, the right goes to his legal representatives. And legal representatives are quite okay, normal. Now they will get a right to file a suit from that date onwards, and the limitation period is available to them. Subsection 4. Where after the disability ceases and before the limitation period expires, the person dies, then his legal representatives can file a suit within the time that is available. What does it mean? Supposing X is a person who is entitled to file a suit. He is suffering from disability. And that disability ceases today, for example. So from today, he will have the limitation period that is prescribed. But even before the expiry of that limitation period, the fellow dies. Then his legal representatives can file a suit. This is what Section 6 of the Limitation Act says. So that is how Section 6 has to be applied. And a word of caution, Section 6 is applicable only for the suits and not for appeals and applications. It is applicable only for the suits. That is another important aspect which has to be considered. Then we will come to Section 7. Section 7 says, disability of one of several persons. What does it mean? For example, there are more than 2 or 3 persons who have a right, or who have a right to enter into a contract, or who have a right to have the contract entered in their favor. Example I am telling. Or some right has accrued to them. Among those 4 persons or 3 persons, one of them is a person suffering from disability. All the 3 persons are quite normal, but all the 4 have got a joint interest. Then what is the consequence? The law says, so where one of them is suffering from a legal disability, and if other person is capable of giving discharge against the person, like on behalf of the person who is suffering from such disability, then Section 6 does not apply. What does it mean? It means to say, let us say, for example, father and 4 sons, father and 3 sons. Father wants to sell her property belonging to a family. Among 3 sons, one of the sons is a minor, or one of the sons is a lunatic. Now, property belongs to the family. It's a joint family property. Father is the karta of the family. Now, as a father and also as a karta, he can always enter into contract on behalf of his minor son. He can always enter into contract on behalf of his lunatic son. And he is capable of giving a valid discharge on behalf of his minor son. Under such circumstances, Section 6 has no application. So Section 7 is an exception to Section 6. Then Section 8. Section 8 says, provisions of Section 6 or Section 7 have no application in case of preemption suits. What do you mean by preemption suit? Right of preemption? Right of preemption means my preferential right to purchase a property before any other person buys. I have a right. For example, A and B are 2 brothers. They have a property belonging to the family. They got it partitioned. One portion fell to the share of A, another portion fell to the share of B. Now B wants to sell the property. A has a right. A has a right to purchase that property before it could be offered to any other person. That is called as right of preemption. So A can tell A, maybe, well, I came to know that you are intending to sell the property. I am ready to buy it for a market value that is prevailing now. That is important. He cannot buy it for a song. A property worth 10,000 rupees can be bought for 1,000 merely because he is a brother. Because other brothers should not be put to loss. So he must be able to say, I am ready to purchase your share for the market value that is prevailing right now. You need not sell it to anybody. This is called as right of preemption. That right is preserved because I don't want a stranger to come and live and reside by my side. Property belongs to my ancestors. It's a joint family property. I don't want the other share of the property to go to the hands of a stranger. I want to have it for myself, if at all my brother doesn't want to reside there. But at the same time, merely because I have got a right, I cannot buy it for a song. I have to pay whatever the market value that is prevailing so as to see that my brother is also not put into loss. So here, what happens? The right of the purchaser is also protected and right of the seller is also protected. Seller will get the same price which he would have otherwise got had he sold the property to some other stranger from his own brother. And secondly, the property of the family would remain intact. Instead of remaining intact with A and B, it will remain intact with A. This is the principle behind right of preemption. And for this right of preemption, section 6 and 7 has no application. This is what section 8 says. Section 9, very important. Section 9, once the period of limitation begins, nothing would stop it. Very important. If the limit, adike, section 6 al helodu enanta, where a person is entitled to institute a suit, on the day if he is a minor, if he is a lunatic, if he is a idiot. Not afterwards, on that day. I have a right to file a suit today and I am suffering from my disability today. If it is tomorrow, no, because the limitation period starts. Section 9 says, once the limitation period commences, nothing stops. Section 9 says, continuous running of time, where once time has begun to run, no subsequent disability or inability to institute a suit or make an application stops it. Neither any disability nor any inability would stop running of a time once the limitation period has commenced. So this will have to be read with section 6 to say, section 6 comes into picture only when a person is suffering from a legal disability on the date on which his right to file a suit has accrued to him, not subsequently. Because if it is subsequently, since the limitation period is already begun, nothing would stop it. So this is so far as section 9 is concerned. Sir, shall we stop it here? Mr. Mahadevaya?
Yes, sir. It is now 7:30.
Oh, yes, sir.
Therefore, sir, I don't wish to stop you, sir. But then,
sorry,
in
time
fact-
nodukulla, sir. Time
ಇಲ್ಲ, sir, we are all so
It has been a
attentive
very
towards-
marathon session. Yes, sir.
we
Very
are all
good, and
so
then,
attentive, sir. It is really wonderful. But then students will lose their attention after so much of time.
Sure, sir, sure.
It is really grateful that you are still having so much of enthusiasm to impart education to all of us, sir.
Yeah.
ಇಲ್ಲ ಆಕ್ಚುಲಿ ಸಾಯಂಕಾಲ 5 ಗಂಟೆವರೆಗೂ ಆರ್ಬಿಟ್ರೇಷನ್ ಇತ್ತು.
Oh,
ಆರ್ಬಿಟ್ರೇಷನ್ ಮುಗಿಸ್ಕೊಂಡು ಬಂದೆ ನಾನು.
great energy, sir. Even at this stage.
So
God's grace, sir.
we will proceed to the next stage of this.
Yes, sir.
Sir,
Yes, sir, yes.
conclude, then we can.
ಏನಾದ್ರೂ ಪ್ರಶ್ನೆಗಳಿದ್ರೆ ಕೇಳ್ಬೋದು. ನನ್ನ ಕೈಲಿ ಉತ್ತರ ಕೊಡೋಕೆ ಸಾಧ್ಯವಾದ್ರೆ ಕೊಡ್ತೇನೆ.
Okay, sir. Okay.
ಸರ್ ಒಂದು ಪ್ರಶ್ನೆ ಸರ್. ನಮಸ್ಕಾರ. ಐ ಆಮ್
Sir, ಹೇಳಿ
ಪ್ರೊಫೆಸರ್.
ಹೇಳಿ ಸರ್.
ನಮಸ್ಕಾರ ಪ್ರೊಫೆಸರ್ ನಾಡಗೌಡ ಸರ್. ನಮಸ್ಕಾರ.
Namaste, sir. Namaste. ಆರಾಮಿದ್ದೀರಾ?
ಆರಾಮಿದ್ದೀನಿ ಸರ್.
Yes, sir.
ಸರ್ ಎಕ್ಸಲೆಂಟ್ ಪ್ರೆಸೆಂಟೇಶನ್ ಸರ್. ಒಂದು ಚೂರು ಬೋರ್ ಆಗ್ಲಿಲ್ಲ.
Thank you very much.
ವೆರಿ ಇಂಟ್ರೆಸ್ಟಿಂಗ್ ಟು ಹಿಯರ್ ಫ್ರಮ್ ಯು. ಸರ್ ಇದು ನನಗೆ ಒಂದು ಸ್ಮಾಲ್ ಪ್ರಶ್ನೆ. You said there are certain articles in the schedule
Yes, sir.
which impose limitations upon appeal, acquittal and conviction ಅಂತ ಹೇಳಿದ್ರಿ.
Yes, sir.
ನನಗೊಂದು ಯಾವಾಗಲೂ ಸಮಸ್ಯೆ ಕಾಡ್ತಾ ಇರುತ್ತೆ ಏನಂತಂದ್ರೆ,
Hmm.
15 years 14 years ಕೇಸಸ್ನ
Hmm.
ಈ ರಿಓಪನ್ ಮಾಡ್ತಾರೆ ಪೊಲೀಸ್ ಪೀಪಲ್.
Hmm.
ಓಪನ್ ಮಾಡಿ ಮತ್ತೆ ಅದನ್ನ ಟ್ರಯಲ್ ಕಂಡಕ್ಟ್ ಮಾಡಕ್ಕೆ ಮಾಡ್ತಾರೆ ಅದನ್ನ ವ್ಯವಸ್ಥೆ.
Hmm.
So, ಈ ತರ ಮ್ಯಾಟ್ರಸ್ ಏನಾದ್ರು ನಾವು ಕಡಿವಾಣ ಹಾಕ್ಲಿಕ್ಕೆ ಅವಕಾಶ ಉಂಟಾ ಅಂತ.
You are talking about criminal cases.
ಎಸ್ ಎಸ್
Yes. Can I have 2 minutes to explain this?
ಸರ್ ಸರ್ ಅಧ್ಯಕ್ಷೀಯ ಭಾಷಣ ಮಾಡ್ಲಿ, ದೆನ್ ವಿ ಕ್ಯಾನ್ ಡಿಸ್ಕಸ್ ಸರ್.
ರೈಟ್.
Okay.
ಓಕೆ
ಓಕೆ ಇರ್ಲಿ.
ಮತ್ತೆ
ಎಲ್ರಿಗೂ ನಮಸ್ಕಾರ. So at the outset, I take this opportunity to congratulate Vijnaneshwara Pratishthan Marturu, particularly Sri Madevaya sir, for having initiated this lecture series in association with University Hubli and also PG Department of Studies in Law of Central University of Karnataka. And it is really a great benefit for all, particularly the students who are pursuing the law courses. And particularly, I am very happy and fortunate to be part of the today's lecture on law of limitation by Sri Dr. Venkat Sudarshan sir, a former principal district judge. And indeed, the lecture have been very informative and useful, and it was really a great brainstorming session for all of us, and particularly for the students, because the way in which sir has explained in a very clear and in a very understandable manner, particularly by quoting very relevant examples, very relevant simple examples, and also referring to various decisions of the Honorable High Courts as well as the Supreme Court of India. And indeed, I am a professor of law, senior professor of law from Bangalore University, and presently I am on deputation as a registrar and now as a in charge vice chancellor of RDPR University. And in fact, this is one of my favorite subject, and I had an opportunity to practice for a few years before my joining my regular teaching profession. And also, I have been teaching this subject for more than 15 years. And of course, now in the RDPR University, since we don't have law courses, I am not teaching presently. But this is one of the very important subjects, as it has been highlighted by Sri Venkat Sudarshan sir, because the law of limitation makes us to be very cautious, particularly whenever we need to exercise our rights or to get remedy through the court of law. As sir has explained, that the law of limitation bars the remedy and not the right. The purpose is to protect the interest of both particularly the dependents, because the law doesn't permit anybody to sleep over the matter and to file the suit whenever he wants to do. And in fact, sir has made it abundantly clear that except few provisions of the law of limitation, almost all the provisions are applicable only in case of civil proceedings. And I think Professor Dashrath sir has raised a question which will be, of course, answered by sir, which is very simple, because particularly in case of criminal cases, the law of limitation will not be applicable, because many a time, because of the lack of evidence or due to non-availability of any clue regarding the offense, or due to failure of the investigating agencies, because the crime, as we all know, is an offense against all, to the whole society. Whereas in case of civil matters, it is only the individual rights which will be affected. So that's how it has been really a great lecture, and particularly the students who have joined on this online platform. So they are really lucky to hear from sir. And in fact, I don't have any other opinion or remarks except all appreciation for a very informative and useful lecture that has been delivered by Sri Venkat Sudarshan sir. And in fact, I must say that this is a lecture which shall be circulated to all, and it should be made available in the YouTube, and it should be referred by all the students who are pursuing law course, particularly who are studying civil procedure code and law of limitation in their 5 year or 3 year LLB. By hearing this lecture, if there are any doubts, because as I know out of my experience as I had little practice experience and also have been teaching this subject, that this subject cannot be taught without the experience of practice, either as a lawyer or as a judge in the court of law. And in this connection, particularly those students who are in an institution wherein the subject is handled by the teachers without the experience of handling cases will be highly benefited, and it is really very useful. So with these few words, once again, I congratulate sir for the very informative lecture, and I thank Sri Madevaya sir for inviting me to be part of this program. I don't know how Madevaya sir came to know that I have been teaching this subject. I don't know whether he has invited me knowing that, or just like that because of his affection for me, as I have been involved in various lectures organized by Vijnaneshwara Pratisthana. And I also thank Sri Amit Deshpande, a senior advocate, whom I in fact not met personally, but we are known to each other online, like the programs like this. So thank you very much.
ಧನ್ಯವಾದ ಸರ್.
ಧನ್ಯವಾದ.
ಕರ್ನಾಟಕ ರಾಜ್ಯ ಗ್ರಾಮೀಣಾಭಿವೃದ್ಧಿ ಮತ್ತು ಪಂಚಾಯತ್ ರಾಜ್ಯ ವಿಶ್ವವಿದ್ಯಾಲಯ ಗದಗದ ಪ್ರಭಾರಿ ಕುಲಪತಿಗಳು, ಕುಲ ಸಚಿವರು ಆದ ಪ್ರೊಫೆಸರ್ ಡಾಕ್ಟರ್ ಸುರೇಶ್ ವಿ ನಾಡಗೌಡ ರವರನ್ನು ಅಧ್ಯಕ್ಷ ಭಾಷಣವನ್ನು ಅವರಿಗೆ ತುಂಬು ಹೃದಯದ ಅಭಿನಂದನೆಗಳು.
Thank you.
Sir can answer the question now.
Yes,
Yeah.
Mr. Dashrath sir.
Yes, sir. Namaskar. Yes, sir.
Namaskar, sir. Sir, your question is, how is it that in a criminal case which was not investigated for more than 10 or 13 years will be again reopened, and investigation will be done, charge sheet will be filed, and trial will be conducted? Am I right?
Yes, sir. Yes, sir.
Yes. I told in the beginning of my lecture itself that the Limitation Act is not applicable for criminal cases. That is, the period of limitation mentioned in this is not applicable for criminal cases, except a few articles with regard to appeal against conviction, acquittal, and revision. So far as the criminal cases are concerned, I would like to draw the attention to Chapter 36 of the Criminal Procedure Code. World Code I am talking about. You have got the equivalent provision in the new BNSS also, which says, especially from section 467 to section 473 of the CRPC, look at the same equivalent provisions in BNSS also. I have gone through both the books. There is no change. The heading of the chapter is limitation period for taking cognizance of certain offences. I am emphasizing the word certain offences. That particular chapter says that no cognizance can be taken by a court after the expiry of the period of limitation, section 467. Section 468 says the limitation period for taking cognizance of the offense is as mentioned below. So clause B of section 468 says that the limitation period for taking cognizance is 6 months if the offence is punishable only with fine, 1 year if the offence is punishable with the maximum of 1 year of imprisonment, and 3 years if the offence is punishable with the maximum of 3 years. It stops there. That means there is no limitation period prescribed for an offence which is punishable with more than 3 years. So once there is no limitation period, for example, an offence is committed today, accused has absconded, he is not found, he could not be seen, and he is found after some offence is committed which is punishable with more than 3 years. Could be a rape, could be a murder, could be an attempt to commit murder, could be a dacoity, could be a robbery, which are all offences which are punishable with more than 3 years. So the investigation may commence after that, and charge sheet may be filed. Then the court will have to take cognizance, irrespective of the number of years, because there is no limitation or control or restraint put on the court for taking cognizance of such offences even after the expiry of long period from the date of commission of the offence. Got it, sir? Hello?
Yes, sir. Excellent, excellent, sir. Excellent.
So for offences which are punishable with more than 3 years, there is no limitation period at all.
Yes, sir.
So once again, I'm telling, go through section 467 to 473 CRPC, equivalent provision of which is found in BNSS also. Yes, any other question? No questions?
Sir, in fact, I have one question, sir,
Sir,
if permitted. Sir,
Yeah,
this
my pleasure.
limitation act also.
if I am able to answer your question, it is my pleasure.
No, sir, it's rather than a question, it is a statement which should evoke interest in the other advocates and students to make research
Please,
in this
sir.
direction more.
Please,
Sir,
sir,
this
please, sir.
Limitation Act 1963
Yes,
is
sir.
essentially based upon the principles which you have read out from the Halsbury's laws of England. So this is
Exactly.
a common law principle derived from the British law regime only.
Correct, sir.
Sir, how far are we right in still keeping these principles making it applicable to the Indian scenario, to the Bharatiya scenario? Are we now ripe enough and wise enough to understand the niceties of these strict rules or the kind of rules that are the principles that are in the Indian Limitation Act? Should we not also march ahead and bring about the necessary changes to the limitation law? And what was the limitation law prior to the British regime coming into India?
Yes. Sir, whatever the explanation that has been given in Halsbury's law of England, which I have read over, it is based on the human conduct. According to me, all the three circumstances which have been mentioned there is based on the human conduct, which has remained the same then also, now also, and future also. Therefore, according to me, even those principles holds good even to this day. Supposing today myself and my friend are very close. Though there is some dispute between us, we will forget and forgive. But the records are still with me. One day we are at loggerheads after a few years, by which time by the ordinary course of limitation, the period is expired. But if there is no limitation act at all, even I can raise that dispute even after 10 years against my friend because it's out of cruelty, or out of a misunderstanding, or out of jealousy, or out of fight. So therefore, my understanding of the law is, whatever the reasons that have been set down in that Halsbury's law of England in the form of 3 principles, which were applicable then, or applicable today also, and applicable in the days to come also, because it is purely based on human conduct. This is my answer, sir. And so far as your question that whether there is a need for any change in the Limitation Act concerned, in my considered view, there is no need. Because the Limitation Act is a very self-contained act. every section covers almost all fields of human activity. Almost all fields of human activity. If we go by section and understand, of course, within my limited knowledge, I am telling, all the sections are self-contained and they are well suited even to this day. This is my answer, sir.
ಧನ್ಯವಾದ ಸರ್, ಧನ್ಯವಾದ. ಪ್ರೊಫೆಸರ್ ಸುರೇಶ್ ಅವರೇ, ತಾವು ಮ್ಯೂಟೆಡ್ ಇದ್ದೀರಿ, ಪ್ಲೀಸ್ ಅನ್ಮ್ಯೂಟ್
Mute ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ?
Okay, in the light of the explanation given by sir, views expressed by the sir, may I make an observation
Please, sir.
that when we need to continue with the law of limitation, I think only remedy is to create awareness about the law of limitation among the people, more particularly the people from villages and illiterates and all that. Many a time, even today in the villages, people lend money, do the transactions with a hope and confidence or belief. But unfortunately, many a time their trust is breached and the things are going against their
Yes.
actual normal practice. So it should be given priority in our legal literacy programs.
Very good, sir. Thank you very much, sir. Thanks for the suggestion
Sir,
given. Very valuable suggestion it is.
Thank you, sir.
ಇಂದು ವಿಷಯದ ಕುರಿತು ವಿಸ್ತೃತ ಉಪನ್ಯಾಸ ನೀಡಿದ ವಿಶ್ರಾಂತ ಪ್ರಿನ್ಸಿಪಲ್ ಜಿಲ್ಲಾ ಮತ್ತು ಸತ್ರ ನ್ಯಾಯಾಧೀಶರಾಗಿದ್ದ ಶ್ರೀ ಡಿ.ಆರ್. ವೆಂಕಟ್ ಸುದರ್ಶನ್ ರವರಿಗೆ ಧನ್ಯವಾದಗಳು. ಇನ್ ಮುಂದೆ ವಂದನಾರ್ಪಣೆ ಮಾಡಲು ಶ್ರೀ ಮಹಾದೇವಯ್ಯ ಕರದಳ್ಳಿ ವಿಶ್ವಸ್ತರನ್ನು ಆಮಂತ್ರಿಸುತ್ತೇನೆ.
Sir, before that, I thank each one of you, sir, for having been patient enough to listen to me what all I have said. And I once again congratulate the Pratishtana and all the three organizations which, with the coordination of which this lecture series has been arranged. And I have been blessed to say that I have this occasion of participating in this lecture series in this beautiful circumstance or occasion. So thank you very much. Thanks to one and all, sir.
Thank you, sir.
ನಾನು ಎಸ್.ಸಿ. ಪಾಟೀಲ್, ಟ್ರಸ್ಟಿ ವಿಜ್ಞಾನೇಶ್ವರ ಪ್ರತಿಷ್ಠಾನ ಮರ್ತೂರು. ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. ವಿಜ್ಞಾನೇಶ್ವರ ಪ್ರತಿಷ್ಠಾನ ಮರ್ತೂರು ಕರ್ನಾಟಕ ಕೇಂದ್ರೀಯ ವಿಶ್ವವಿದ್ಯಾಲಯ ಕಡಗಂಚಿ, ಕಲಬುರಗಿ ಮತ್ತು ಕರ್ನಾಟಕ ಕಾನೂನು ವಿಶ್ವವಿದ್ಯಾಲಯದ ವತಿಯಿಂದ ಗೌರವಾನ್ವಿತ ನ್ಯಾಯಮೂರ್ತಿ ಡಾಕ್ಟರ್ ಮಾ ರಾಮಜೋಶ್ ರವರ 94ನೇ ಹುಟ್ಟುಹಬ್ಬವನ್ನು ಆನ್ಲೈನ್ ನಲ್ಲಿ ಸರಣಿ ಉಪನ್ಯಾಸಗಳ ಮಾಲಿಕೆಯಲ್ಲಿ 4ನೇ ದಿನದ ಉಪನ್ಯಾಸ ನೀಡಿದ ವಿಶ್ರಾಂತ ಪ್ರಿನ್ಸಿಪಾಲ್ ಜಿಲ್ಲಾ ಮತ್ತು ಸತ್ರ ನ್ಯಾಯಾಧೀಶರಾಗಿದ್ದ ಶ್ರೀ ಡಿ.ಆರ್. ವೆಂಕಟೇಶ್ ಸುದರ್ಶನ್ ರವರಿಗೆ ಧನ್ಯವಾದಗಳು.
Thank you, sir. Thank you.
ಮತ್ತು ಕಾರ್ಯಕ್ರಮದ ಅಧ್ಯಕ್ಷ ಸ್ಥಾನ ಅಲಂಕರಿಸಿದ ಕರ್ನಾಟಕ ರಾಜ್ಯ ಗ್ರಾಮೀಣಾಭಿವೃದ್ಧಿ ಮತ್ತು ಪಂಚಾಯತ್ ರಾಜ್ಯ ವಿಶ್ವವಿದ್ಯಾಲಯ ಗದಗದ ಪ್ರಭಾರಿ ಕುಲಪತಿಗಳು, ಕುಲಸಚಿವರು ಆದ ಪ್ರೊಫೆಸರ್ ಡಾಕ್ಟರ್ ಸುರೇಶ್ ವಿ ನಾಡಗೌಡರವರಿಗೆ ತುಂಬು ಹೃದಯದ ಅಭಿನಂದನೆಗಳು.
Thank you, sir. Namaste.
ಕರ್ನಾಟಕದ ಕೇಂದ್ರೀಯ ವಿಶ್ವವಿದ್ಯಾಲಯ ಕಡಗಂಚಿ, ಕಲಬುರಗಿ ಡೀನ್ರಾದ ಶ್ರೀ ಬಸವರಾಜ್ ಕೂಬಕಡ್ಡಿ ಅವರಿಗೂ ಮತ್ತು ಕರ್ನಾಟಕ ಕಾನೂನು ವಿಶ್ವವಿದ್ಯಾಲಯದ ಮಾನ್ಯ ಕುಲಪತಿಗಳವರಿಗೆ, ವಿಶ್ವವಿದ್ಯಾಲಯದ ಅಂತರ್ಗತ ಬರುವ ಕಾನೂನು ಮಹಾವಿದ್ಯಾಲಯಗಳ ಪ್ರಾಚಾರ್ಯರು, ಉಪನ್ಯಾಸಕರು, ವಿದ್ಯಾರ್ಥಿಗಳಿಗೆ ಧನ್ಯವಾದಗಳು. ಉಪನ್ಯಾಸಕರಿಗೂ ಹಾಗೂ ವಿದ್ಯಾರ್ಥಿಗಳಿಗೆ ಧನ್ಯವಾದ. ಅನನ್ಯ ವಿಶ್ವವಿದ್ಯಾಲಯಗಳ ಮಾನ್ಯ ಉಪಕುಲಪತಿಯವರಿಗೆ, ಉಪನ್ಯಾಸಕರು, ವಿದ್ಯಾರ್ಥಿಗಳಿಗೆ, ಮಾನ್ಯ ನ್ಯಾಯಾಧೀಶರು ಹಾಗೂ ನ್ಯಾಯವಾದಿಗಳಿಗೆ, ವಿಶ್ರಾಂತ ರಾಜ್ಯಸಭಾ ಸದಸ್ಯರು, ಪ್ರತಿಷ್ಠಾನದ ಮಾನ್ಯ ಅಧ್ಯಕ್ಷರಾದ ಶ್ರೀ ಬಸವರಾಜ್ ಪಾಟೀಲ್ ಸೇಡಂರವರು ಮತ್ತು ವಿಜ್ಞಾನೇಶ್ವರ ಪ್ರತಿಷ್ಠಾನದ ವಿಶ್ವಸ್ತರೆಲ್ಲರಿಗೂ, ಸ್ವಾಗತ ಮಾಡಿದ ಡಾಕ್ಟರ್ ಬಸವರಾಜ್ ಕೂಬಕಡ್ಡಿ ಅವರಿಗೂ, ತಾಂತ್ರಿಕ ಸ್ವಾಗತ ಮಾಡಿ ಶ್ರೀ ಮಹಾದೇವ ಕರದಳ್ಳಿ ಅವರಿಗೂ, ಸಹಾಯ ನೀಡುತ್ತಿರುವ CUK ಸಂಶೋಧನಾ ವಿದ್ಯಾರ್ಥಿಗಳ ಶ್ರೀ ಕೃಷ್ಣ ಶರ್ಮಾ ಮತ್ತು ಮಾರಿ ರಾಗಿಣಿ, ಉಪನ್ಯಾಸ ಯಶಸ್ವಿಯಾಗಿ ಪ್ರತ್ಯಕ್ಷ ಪರೋಕ್ಷವಾಗಿ ಸಹಕರಿಸಿದ ಎಲ್ಲರಿಗೂ ಧನ್ಯವಾದಗಳು. ಈಗ ಇಂದಿನ ಈ ಕಾರ್ಯಕ್ರಮ ಶಾಂತಿ ಮಂತ್ರದೊಂದಿಗೆ ಮುಕ್ತಾಯವಾಗುತ್ತೆ. ಸರ್ವೇ ಭವಂತು ಸುಖಿನಃ, ಸರ್ವೇ ಸಂತು ನಿರಾಮಯ, ಸರ್ವೇ ಭದ್ರಾಣಿ ಪಶ್ಯಂತು, ಮಾ ಕಶ್ಚಿತ್ ದುಃಖ ಭಾಗ್ ಭವೇತ್. ಓಂ ಶಾಂತಿ ಶಾಂತಿ ಶಾಂತಿ. ನಮಸ್ಕಾರ, ಧನ್ಯವಾದ.
Namaste, sir. Thank you.
ಈ ಉಪನ್ಯಾಸ ಸೆಂಟ್ರಲ್ ಯೂನಿವರ್ಸಿಟಿ ಆಫ್ ಕರ್ನಾಟಕ ವೆಬ್ಸೈಟ್ ಅಲ್ಲಿ 3-4 ದಿನದಲ್ಲಿ ಅಪ್ಲೋಡ್ ಆಗುತ್ತೆ ಸರ್.
Thank you.
4 ಉಪನ್ಯಾಸಗಳು. ಧನ್ಯವಾದಗಳು ಸರ್.
Thank you. Lagout ಆಗ್ಬೋದಾ?
ಆಗ್ಬೋದು ಸರ್. ಧನ್ಯವಾದಗಳು.
Thank you very much, sir. ದೇಶಪಾಂಡೆ ಸಾಹೇಬ್ರೆ,
ಸರ್ ಧನ್ಯವಾದ ಸರ್. ಧನ್ಯವಾದ.
ನಮಸ್ಕಾರ ಸರ್. ನಮಸ್ಕಾರ.
Namaste, sir. ಎಲ್ರಿಗೂ ನಮಸ್ಕಾರ.
ನಮಸ್ಕಾರ
ತಮ್ಮೆಲ್ಲ
ಸರ್.
ಬಿಸಿ ಶೆಡ್ಯೂಲ್ ಅಲ್ಲಿ ನಮಗಾಗಿ ಸಮಯ ಮೀಸಲಾದ ವಿಶೇಷ ಧನ್ಯವಾದಗಳು ಸರ್.
ಥ್ಯಾಂಕ್ ಯು
Yes,
ಸರ್.
sir.
ಥ್ಯಾಂಕ್ ಯು ಸರ್. ಥ್ಯಾಂಕ್ ಯು ವೆರಿ ಮಚ್.
ನಿಮ್ಮ ಆಶೀರ್ವಾದ ಯಾವಾಗ್ಲೂ ಹೀಗೆ ಇರ್ಲಿ ನಮ್ಗೆ.
ಯಾವಾಗ್ಲೂ ಇದ್ದೇ ಇರುತ್ತೆ ಸರ್, ನೀವೇನು ಯೋಚನೆ ಮಾಡಬೇಡಿ. ಸೊ ದೇಶಪಾಂಡೆ ಸರ್, ಹೌ ಆರ್ ಯು ಸರ್?
ಫೈನ್ ಸರ್.
ಎಲ್ಲ ಚೆನ್ನಾಗಿ ನಡೀತಾ ಇದೆಯಾ ಸರ್?
ಎಸ್ ಸರ್, ಚೆನ್ನಾಗಿ ನಡೀತದೆ.
ವೆರಿ ಗುಡ್ ಸರ್, ವೆರಿ ಗುಡ್.
ಮತ್ತೆ ತಮ್ಮನ್ನ ಭೇಟಿ ಮಾಡ್ತೀವಿ ಸರ್. ಮತ್ತೆ ಇನ್ನು ಬೇರೆ ಬೇರೆ ಕಾರ್ಯಕ್ರಮಗಳನ್ನ ಇಡ್ತೀವಿ.
ಆಯ್ತು ಸರ್.
ಸಹಯೋಗ ಬೇಕು.
ಖಂಡಿತ, ನಾನು ಅವತ್ತೇ ಹೇಳ್ಬಿಟ್ಟಿದ್ದೀನಿ ಸರ್ ತಮ್ಗೆ.
ಬ್ಲಾಂಕ್ ಚೆಕ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್.
ಏನಂದ್ರಿ?
ವಿಜ್ಞಾನೇಶ್ವರಿಗೆ ಬ್ಲಾಂಕ್ ಚೆಕ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂದೆ.
ನಮಸ್ಕಾರ ಸರ್.
ನಮಸ್ಕಾರ ಸರ್. ನಮಸ್ಕಾರ.
So kind of you. ನಮಸ್ಕಾರ ಸರ್. ನಮಸ್ಕಾರ ಸರ್.
Thank you very much.
Thank you very much.
Thank you very much, sir.
Thank you sir. ಲಾಗೌಟ್ ಆಗ್ತೀನಿ.
ಆಯ್ತು ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
ಓಕೆ.